My lordship, become listing of one item, my lordship.
What?
WBC, a foreign stability matter.
For motion?
Admission, my lordship.
What admission?
Motion, my lordship.
What admission? When did you file?
It was last posted on 15 to 2022, my
It'll
lordship.
come up. Don't worry, it'll come up.
Urgency, the police is
What
searching.
urgency?
Sir, police is searching him.
Huh?
Police is searching him.
Police searching him. To go to the police. What's the problem?
Lordship may allow.
Okay.
Deeply obliged.
If I more serious role.
May I please, Lordship, Lordship, I beg to mention a IA Lordship for listing. And
IFOR.
IA for amendment of order Lordship, and then the main petition has already disposed, but there is some mistake there.
May I please, Your Lordship? Actually, for listing of the IA, Your Lordship, by tomorrow, it's an urgent matter because, Your Lordship, the last order which was passed by this court has not been complied with by the SP board at Gulaghat. And they said that they are not satisfied with the order. So he is still in the detention for the last 2 months. Will be taken up tomorrow.
Day after tomorrow.
Public. Please, Your Lordship. I beg to mention for listing of the WPC.
Why? It was not listed earlier.
No, Lordship.
Never been listed.
Yesterday we have filed it.
It will come up. Don't worry. You have filed yesterday, it will come up.
Public.
Daily list for motion item number 1.
Records are here.
My lordship, in this case, the father as a witness also given his statement, my lordship. And his father's name is appearing, but daughter's name has not appeared. Daughter has been, and my lordship, in this case also police is searching her, my lordship. The interim protection may be granted, my lordship.
Father has appeared.
Yes, father as a witness appeared, my lordship.
What is the father's affidavit? Father's statement.
Page 58, my lordship. Recorded his repository, my lordship.
Page 58.
Yes, my lordship.
Okay. Notice.
Interim may be granted, my lordship.
A notice was issued earlier or what?
Yes, my lordship.
Notice has been issued. Okay.
Matter was fixed for hearing on 1910,
Yes.
Lordship.
Okay. We have perused the records. The records have been received. The matter can be heard finally. In the meantime, if the petitioner has not been detained on the stand of the impugn of the surrender. Huh?
Deeply obliged.
Item number 2 and 3.
Maybe Lordship. But this is the ex parte order, my lord. And the finally see, my lord, page 33 and 12, my lord. Within 10 days, 4 date was fixed, my lord. The petitioner appearance, but he was not submit any document, my lord. Within 3 days, my lord, 1 date is 1/6, next is 6, next 7, 8. Then only 10 days, 4 date is. And on the medical ground, that was not considered. So expert was.
What medical ground?
My lord, he was not able to come to court, my lord, in reflects, my lord, orders, my lord.
What have you mentioned?
My lord, page 34, my lord.
But no ground was produced before the tribunal, Lordship, page
So
34.
there is mention of medical ground, no medical record was produced.
And only,
One medical ground.
my lord,
Okay.
actually, my lord, and in fact, my lord, when the petitioner received the notice, my lord, and he was engaged the counsel, my lord. But he got some document, my lord, as well as the petitioner was not shot well, my lord. So he was took time, my lord. But only time, my lord, 1, 2 days, 3 days he was allowed, my lord. Landed tribunal, my lord. Only 10 days, 4 days is allowed, my lord. How he will file, my lord, retained statement, my lord? One is, my lord, 6, 7, 6, next is 8, 6, and 10, 6, my lord. So ex parte was expired. And the
Now
last,
you are ready with the written statement.
no, my lord, nothing, my lord.
Are you ready now?
Yes, my lord, I'm ready, my lord.
When can you file?
My lord, my lord, sometime,
For some time.
at least, Manu, the petitioner shall appear and file their written statement and evidence also.
Be
my lord.
specific lordship. He has to give a specific time.
You
2
give a
weeks-
time when you want to file
2
the,
weeks, within 2 weeks, let him file lordship.
My lord, 1 month, my lord, minimum
1
1
month
month.
would be too much. 2 weeks.
My
is
lord,
sufficient.
document is
He
required,
knows
my
there's a
lord.
Proceeding against him, lordship. He's aware
When he
of the
applied, my lord,
proceeding.
certificate, copy, my lord. The officers, at least they took time, my lord. So how problem is there, my lord?
Just
you
now,
make a mention in the application that I have applied for certified copy, I have not been given. That's what Muslim Mondol says.
Yes.
The authorities are supposed to give the copies promptly. You make a mention
and just
that
now
yes, I
my
have
friend-
applied on so and so, they have not
My lord-
given, so give us time.
My lord, so
My
my lord,
friend
at
has
that
just now
time
said
afterwards,
he's ready
he
with
get
the
document, my lord.
document.
Now I am ready to appear, my lord.
No, you apply all those certified document,
Ah.
whatever from the authority, you say that I have to file written statement. If you don't file, I cannot file. That will be a good ground for interference by the court. If the tribunal do not really take it, because that's what the Muslim Mondol says,
Yes, my lord.
that the authorities are supposed to promptly issue certified copies. Unless you make those applications, how this court will appreciate? Huh? We will allow, we'll give them time.
3
If you have,
weeks time, lordship.
huh?
3 weeks time.
3
to
weeks time.
file
You within
WS.
3 weeks, you file it. If you have any problem, you say that. You keep on record. That's how the thing has to go on. Otherwise, without record, how the tribunal also understand, appreciate it, whether you have a difficulty
Has
or
to
not.
be a cooperation from both the sides.
Yes,
lordship.
yes. And Mr.
HLM.
and a counsel for the penal, also and a counsel for the सबका नाम लिखो. In this petition challenge the ex parte order dated. Page
27,
number?
2022.
Page.
Page, my lord, 32, 33, my lord.
Ex parte order dated
27.
ex parte 27,
27,
27.
my lord. Yes, my lord.
27/6/2022 passed by the Learned Forest Tribunal, Jorhat, Assam in FT case number FTG 2042/2011, page 33, corresponding to SP's inquiry number so and so. It is a plea of the petitioner that the petitioner was not afforded sufficient time to file the written statement. The time granted, though the Learned Tribunal had granted time on 3 occasions, but it was too short to collect the materials and collect the material documents and file the same by way of written statement. Full stop. Like when it has been submitted that if the petitioner is willing to challenge the said proceeding in he is in India, not a foreigner, but however in absence of proper opportunity to file a written statement, he will be deprived. He will be seriously prejudiced. We have also heard Ms. Verma, who submits that it's not that the tribunal did not afford sufficient opportunity to the petitioner, as the record would reveal. He was given as many as 3 times, 3 times,
Yes, my lord.
lordship.
3 times to file a written mail, which he failed, and as such, the petitioner has to be blamed for the situation he finds himself. Full stop. We have heard the Learned Counsel for the party. We also perused the order. Impugn order 27/6/2022. From the record, it appears that the Learned Tribunal had granted time to the petitioner to file his written statement on
7/6. One is 1/6,
1/6/2022, 7/6/2022
8/6.
and 8/6/2022. In our opinion, we are of the view that since the petitioner, since obtaining documents, certified documents may take time, he may be given some more time to file his written statement. Her or his lady or what?
My lord,
Lady
male.
Maharuddin.
And second is the wife, my lord.
What is this? Why her in the opinion? Okay. Accordingly, we allow this petition by setting aside the impugn ex parte order at 27/6/2020. However, the petitioner will file his written statement within a period of 3 months, 3 weeks from today. 3 weeks from today. 3 weeks from today. And if there's been any difficulty in filing the written, in obtaining certified copies of the documents, he may inform the tribunal accordingly. Inasmuch as it is also held a that Muslim Mundal. They are also held by the full court, full bench of this court in Muslim Mundal versus so. Where is the para number?
Sorry, my lord.
Hey, what? Sorry, you are the one who
One
don't come
ninety-
prepare anything.
895.
Next time I'll pass the orders in our chambers. We'll sit ourselves. We don't require any lawyers. Huh? We just sit, open the file, pass the order. What is the point of coming here?
Perhaps 95. para number. 95 on.
Para 99, huh? Where it has been held by Honorable Supreme, by the full bench of this court in so and so. That certified copies of document, that fair trial and reasonable opportunity required to be afforded also includes supply of certified copies. Just para 99. In view of the above, we have the view that, of course, accordingly, the presentation allowed by setting aside during the pendency of this petition, the petition will be allowed to remain on bail on punishing a bail bond of so and so. So satisfying SP border
SP border my lord, Golaghat, my lord.
follows. Okay. Next,
My lord, his wife, my lord. Same person.
huh?
Next is wife, my lord.
Next is why
Yes, my lord.
Same ground.
Same ground, my lord.
opinion, only the name.
you club to then okay, same.
Hello.
Only the names would change.
Huh?
Only the names would change.
Okay, okay,
Otherwise, everything is common lordship.
okay.
Hello.
Item number 4.
Item
Item number 4.
contested matter, my lord. Gavura and his uncle examined.
Gaumbura.
Gavura.
Does he know him?
Yes.
Do you?
Yes.
Huh?
He also examined.
Yes, Gaumbura and uncle. Okay.
And
Examine lordship.
Notice record interim. Yes.
yeah, outside.
Item number 5.
May it please your lordship.
Yes.
Lordship, it's a contested matter. Order is at page number 34, lordship.
34.
Yes, lordship. Lordship, in this case, her elder brother came as DW2, deposes as DW2. DW3 is the Gambura of the said village, and even she has submitted her voters list of 1966-70 of her father and mother. Moreover, the elder brother, who is DW2 in the present case, had casted votes along with their parents.
Notice record interim. Yes.
Much of it.
Item number 6.
My lord, the petitioner's father's name appeared in the voter list 1966, my lord, and her own sister was examined as DW2, my lord.
Examine.
Notice record interim. Yes.
Item number 7.
Yeah. Lordship, in this case, my lord, elder sister, my lord, examined. The secretary of Gao Panchayat examined.
Notice record interim.
Obliged.
Item number 8.
With please, your lordships. My lord, here it is contested case, my lord. The petitioner's father was examined as well as headmaster, my lord. The petitioner is behind, my lord, in the custody, my lord.
Father has been examined.
Yes, my lord.
What is the father's
My
statement?
lord,
The statement could be corrected, but it is reflected in the opinion itself, my lord.
Page,
Page 47, my lord, EW2, my lord. Page 47. my lord. Abdul Salam, my lord.
page 47,
My lord, 40,
page 40?
47, 46, almost every page is my lord, his father's. He was.
Where is it? DW2.
My lord. 46 also, my lord, kindly see.
This is the name of the father, maybe Karan was in the case and the name. A. Salam, Abdul Salam. We'll examine it. Father has come, okay. It has been submitted to the father and the
And the school headmaster, my lord.
you had testified in the before a tribunal to support the claim of the petitioner in Indian. We'll examine the matter, call for the records. In the meantime, the petitioner who has been in detention under where?
My lord, Shivsagar, Jorhat detention camp, my lord.
Then came, maybe released on bail, subject to furnishing a bail bond of rupees 5,000 security like amount to the satisfaction SP border.
SP border, Shivsagar, my lord.
Baki sab all conditions.
Lordship, this order will go in the IA lordship.
I, huh? In I में लिखना है. Okay, I disposed of, yes.
Item number 9.
My lord, here, my lord,
Sukyan Das.
yes, my lord. Here, my lord, the neighbor was, and Gabra was examined, my lord. He
Never,
accepted,
never.
my lord.
How long they have been knowing each other?
From childhood, my
From childhood.
lord. And Gabra also examined.
Okay, notice record entered.
Published.
Item number 10.
This matter may kindly be passed over.
Pass over, yes, next week, yes, next. Yes, next.
Item number 11.
Here to contested case, my lord. Petitioner has been examined as Schedule 1. His elder brother also submitted written statement, evidence in say, but ultimately he not come forward.
Why? He got
There
scared.
was some difficulty, he is not
What
come
difficulty?
forward.
Huh?
It is not mentioned. And the learned tribunal held that the petitioner failed to. disclose
Why the brother didn't come? Huh?
It is written statement. Term of judgment.
Yes. So what is the evidence that you are an Indian?
My father's mother's name appeared in the voter list.
Show your father's and mother's name.
Here. Page 66.
Please.
My lord, first, it translated to page 28. my lord.
Page 28. What is your father's name?
Harish Sheikh.
Huh?
Harish Sheikh.
Harish Sheikh.
Yes. my lord.
1966.
66.
Then
Then my lord, 1971, my lord. 70, my lord. Page 30.
Harish Sheikh, Komar.
Page 30.
Son of Komar.
Page 30.
Same village?
Same bill.
Garala Suti.
Then my lord, 55. The page 32, my lord. 1985 voter list. 1985 voter list, my lord.
Page
Page 32.
32.
Yes, my lord. And relevant
Harish
page
Sheikh,
33.
Harish, male. Harish.
And in the meantime, my lord, due to himself, he shifted to village Alaboti and their name appeared.
Yes.
Standing law.
Notice record interim, yes.
Item number 12.
It's a contested case, Lordship. In this case, Lordship, elder brother and the Gaubura was examining.
Elder brother, Gamura.
Standing law.
Notice record interim.
Item number 13.
In this case, Lordship, the elder brother of the procedure was examined.
Elder brother,
Yes, Lord.
Examine.
notice record interim.
Right.
Item number 14.
Lordship, this is a contested matter, Lordship. His cousin, Gavura and Latmondon has examined.
Gambura. Cousin,
Cousin.
real cousin.
Yes,
How he is related?
uncle's sons.
Uncle's son,
And apart from this, your lordship, the inquiry report almost blank.
almost blank. Okay,
Examine lot.
notice record of interim.
Item number 15.
This case, lordship, the petitioner's father came to India from East Pakistan on 8/5/1966. And lordship, the migration certificate is also there, lordship, at page 15.
Notice record interim.
Lordship, I am behind the bar, lordship.
Yeah, the behind a bar.
And the detention came at Tezpur.
Huh?
Granted in a-
Detention came at Tezpur. I filed an I also, lordship.
Listen,
Okay,
he's already got the order.
Bail order. Bail order for arrest.
Yes.
okay, इसमें लिखो notice record. हाँ, I में लिखो. Who had appeared before in the it is the case of the petitioner, the petitioner's father had
Lordship, came to
Came to India.
in 1966. Lordship.
1966. Yeah, and what is that certificate?
Lordship, that certificate is
Page-
at page 15.
Page 15. Certificate and was petitioner's father Madhusudan
No,
Mandal.
this certificate is regarding maternal grandfather, Lord.
But what is your
My father shifted in from East Pakistan
this
in
is a maternal, huh?
66. And the opinion of the tribunal is there, lordship, where I have.
No, this migration certificate,
Exhibits are there,
migration certificate issued in whose name? This migration certificate, page 15, issued
Page
in
15 is maternal grandfather, lordship.
maternal grandfather.
Lordship.
What is the maternal grandfather's name?
Maternal grandfather name is lordship, Madhusudan Mandal.
Petitioner plea is that the petitioner's maternal grandfather Madhusudan Mandal had migrated from Bangladesh, lived in East Pakistan in the year 1964.
Four.
And what about your father?
Father shifted in the year on 8/5/1966.
And his father also shifted from Pakistan,
Pakistan.
huh?
Lordship.
Bangladesh, in Pakistan, East Pakistan on
On 8/5/1966.
which have been duly submitted documents relating to which have been duly submitted tribunal. However, tribunal did not believe the same. We'll examine the matter. In the meantime, petitioner who is stated in detention. Where are you in detention? Huh? Detention may be released on bail subject to furnishing of bail bond notice. SP border?
SP Border Dhemaji.
Dhemaji.
Lordship.
I had this book.
Deep level.
Supplementary list for motion item 27.
May I please, lordship?
What is this?
Lordship, kindly adjourn the matter for the time being. My senior is on court number 6.
Next week.
Lordship,
This must be on the prayer of Mr. Spencer. Yes, next.
Daily list for admission item 16.
Ali Akbar.
I appear on behalf of Jessica Gogol, lordship. This is a contested matter, lordship.
Huh.
Lordship, petitioner is cornered by the lordship.
Records have been received, so we'll fix for hearing.
Yes, lordship.
Okay, since the records have been received, the matter will listen for hearing. Yes, next.
In the meantime, lordship, interim continue, lordship.
Ali interim order will continue. Yes, next.
Item 17.
Yes.
Please, lordship, in this matter, my lord, the LC has been received, may be fixed for hearing.
Okay, since the records have been received, the matter will listen for hearing. Yes, next. Huh?
Same, my lord.
Say item number?
No, 18.
Item same order. Nineteen.
Item number 19.
Your lordship.
Records have been received.
Yes.
The matter can be listed for hearing. Yes, same order.
Item number 20.
Records have been received.
Same order.
Item number 21.
Same order. Records received? No.
It is Jutiketa, my lord.
Where is your guitar? Okay, what is the first order?
My lord, by the same tribunal, my lord. First
Yes.
Opinion.
First
First
opinion, yes.
opinion is, my lord, his lordship may kindly see, page 25, paragraph 4.
Page 25.
My lord, name of the petitioner is Abdul Jabbar.
I have heard,
Records are not there. Both the records may be called.
huh?
Records are not there.
Record four files LCR 6050. 6050 is there. What about the earlier record? No. Did you mention before a tribunal? That is a
Yes, my lord, in the next, my lord,
and what did the tribunal say?
tribunal, my lord, declared foreigner, my lord.
No. When you mention that you have been already declared Indian, What did the tribunal say?
Lordship, may kindly see page 62, my lord,
Page 62.
page 62.
Yes.
Lordship, may kindly.
Document
My
exhibits
lord,
is a survey
document
copy
exhibit
judgment.
number 7.
If the herbo wanted for that has been declared, the said judgment is deferred by me. On going through judgment, he found a possible judgment, there was no provision. Sorry, you can't do that.
The order
We can't defer.
definitely.
Right, wrong, you should have challenged it.
The opinion was passed in 25/5/2018, madam.
Huh?
The opinion was passed on 25/5/18.
Anyway, it doesn't matter.
Let the records come, my lord.
What record? Record is here.
Record of the second case is
Record is 5060. Record is here.
next one, my lord. FD case number 862 of 2012.
No, what the record will show. Let us see the original certified copies here. Let us see Idris Ali. You are Abdul Jabbar.
Abdul Jabbar, my lord.
But
Idris
earlier
Ali-
was Idris Ali.
Idris Ali, brother, my lord.
Huh?
Brother, my lord. Earlier
Idris
case, my lord.
Ali Abdul Jabbar of village Dokhin Senimari. Dokhin Senimari. PS Lohari Ghat. And in this case, Exhibit A, what is Exhibit A? What are the similarities in the document to us?
Lordship, may kindly see this in the said case also, my lord.
Yes.
Abdul Jabbar adduced evidence, my lord.
In the said case.
In the said case also, my earlier one also. That, my lord, I have, and my lordship, may kindly see page 46. That is the written evidence of Abdul Jabbar. All the documents are same in both the cases, my lord.
So no, this school voter list Lohari Ghat. 35 copy of 1989. Have you annexed any document? In this 1989, let us see.
1989, my lord.
Yes.
Certified copy of voter list,
Yes.
my lord. Yes, my lord. Page, my lord, 30.
Huh?
Page 30, my lord.
Page 30.
30. That is 1999, my lord. Voter list. Abdul Jabbar.
Page 13. Page 89.
30, my lord.
Abdul Jabbar.
Yes.
81 Lohari Ghat.
South Chenimali village. Village, Mojala and
Nineteen 66, 84
No.
Lohari Ghat. Let us see.
1966, my lord. I'm coming, my lord.
Yes. 84 Lohari Ghat.
1966, my lord. Page, my lord, 16. 60. Page 16, my lord.
16.
Yes, my lord.
So we call vote list 84 Lohari Ghat. The name of father and mother of father is
Father is Afsar Ali, man. Afsar Ali.
Afsar Ali.
Yes, my lord. Number 1.
And mother
Mother is, my lord. Mother name is Travis not there. Jinu Bibi or something. Jinu
Because
Bibi. Jinu Bibi.
because father and mother Jinu Bibi.
My lord. You need evidence also stated.
OP3 is it Abdul Jabbar.
Abdul.
OP3. Mr. Payang, the name of Abdul Jabbar also reflected same mentioned in the earlier certified copy of the order.
That's true, my lord.
Then what is the point?
My lord,
Why the
if
point
records are
keeping-
there, I may go through the records, my lord.
The good
Because,
record is here.
yes,
They have to
and my lord, the,
record, you can go through.
and the issue, my lord, what I have seen, my lord, the Abdul Jabbar and Idris Ali, they are tried together in earlier, my lord, earlier proceedings.
You see whatever is it. Next week.
My lord, the, whether the next case is there,
Huh?
the earlier case, record of the earlier case is there, that is.
The earlier case is not there, only this present case. But then certified copy was same. Idris Ali, OP3.
If my lord, the
Day
earlier
after tomorrow,
records of
Today is
earlier
what
cases-
day? Today is Wednesday. List next week,
My lord,
Monday. You go through it, we'll
No,
see that.
What
Once
I
you
want,
go,
what I wanted to say, my lord, whether the reference was there in earlier case, matter, that's what I want.
what reference?
Reference against it, Abdul Jabbar was there. or not.
Is there because that's what the opinion was
My lord,
rendered.
the reference from-
Abdul Jabbar and others. Abdul
Yes, my
Jabbar.
lord,
reference.
that's why, my lord.
Yes,
Abdul
the
Jabbar and-
the reference there, in fact, in the earlier opinion, the order is, there is a specific reference to Abdul Jabbar only, OP3. OP3 was the Abdul Jabbar in that earlier reference. You have a look, no problem.
No, that's
Monday.
why, my lord, if the earlier record is called, go through the records, whether the specific reference was there, because without the specific reference, the tribunal cannot go.
See,
That,
we cannot go into that. It is not your case.
no, my lord, that.
You cannot
because-
use all those collateral because
No, that,
see that this OP3 is there, the reference, we don't know. Whatever it is, there's a finding.
no, my lord, this is.
The, see that opinion that Abdul Jabbar Indian is there, that has not been challenged. Right, wrong, we don't know how it has come. This right, wrong, it is there. If you have any issue with that, you challenge it, then you come up. That is a plea, you cannot take it here. Yes, next.
For orders, item number 22.
Card Banu Nessa. Yes, anybody for Card Banu Nessa? Records are here, list for hearing. Since the records are here, records have been listed in the matter list for hearing. Next,
Item number 23.
what is this review? Huh? Card Banu? Oh, just a minute. Just a minute, Card Banu. Non appears with petitioner called, though just my appearance. This is a matter to awaiting is was a report submitted by current council name does since the matter let us.
That is matter, my lord.
Was a report, oh, expired. Card Banu has expired. Oh, submission report from district legislation authority. Family members of petition must remit. The said petition expired in the year 2019. $67. There's survey also.
No, but,
Oh.
some amicus were appointed earlier occasion.
Correct. At that time, because then the report we called for report from the legal service authority, they have submitted that she has died. Then in that case, what to do? We close it, we leave it any legal heirs to challenge as and when they desire. Because Card Banu has died.
I'm referring in the item 22 minor.
22 gone.
Yes.
This is
He
20,
said
this is, he has been appointed for amicus.
Oh, this is 22. Okay, you're the,
Yes, yes.
okay, you are
I filed DK Bakchi, ma'am.
I have filed wakalatnama. Last occasion direction was given to file wakalatnama. Earlier different councillors.
On the premier by DK Bakshi, land transaction matter, okay. Now your,
I filed wakalatnama.
your file Wakalanama,
Yes.
who has signed your Wakalanama? Who has signed the Wakalanama? Somebody must have signed the Wakalanama.
Yes, I have been Dinamani Sharma who engaged me, my lord.
Correct?
Yes.
Then in Wakalanama is a contract, no?
Yes.
Authorization by a person. Who is the person who is authorized to appear?
I have petitioner, my lord.
Who is the petitioner?
My lord, Kadbhanu Nesa.
But Carbon is dead, as per the report submitted by the legal service authority. When she signed before her, she died or what? When?
My lord, my
After she died, she can't sign obviously.
yes, obviously, my lord.
So when the Wakalanama was signed,
My lord, I have been given the wakalatnama by Mr. Dinamani Sharma, who is now the FT, my lord. He's this particular petitioner was his client, my lord.
you have the Wakalanama with you.
No, my lord. He said that he has filed, my lord.
Wakalanama. Okay, fine, no problem. But only problem is that the Wakalanama. D Sharma, you are D
No,
Sharma.
no, I am DK Bakshi, my lord.
You are DK Bakshi. See, Wakalanama is only, this is the earlier one, 13 July 18, when she was alive. So 19. That you file a Wakalanama?
I was told that he has filed the wakalatnama.
Oh, but in the Wakalanama also you have to sign, no?
No. Initially I did not, because I only submitted last time that I am the engaged counsel.
After that, have you signed any Wakalanama?
No, my lord.
You have not signed any Wakalanama. See, in the meantime, we have the report that she has died. Then what to do?
My lord, then in that case, my lord, lordship, a substitute.
In the meantime, what you do is that you find out the descendants, they may like to challenge it,
Yes.
because the mother, Kadbhanu Nesa, has died. Because if she is declared a foreigner, then all the children will be affected, na?
I'll take the next period.
Okay, Mr. Bakshi is not here anyway. Mr. Bakshi submits that Lana Council for the petitioner submits that he will try to contact the legal heirs of Kadbhanu Nesha, who is reported to have expired sometime on expired on 22/6/2019 as per the report submitted by the District Legal Service Authority, Kolpara.
Deeply.
At least after a month. In the meantime, find out,
Yes.
tell them they can substitute themselves and challenge it. Whatever you want to do, you do it.
Yes, ma'am.
In the meantime, you get a Wakalanam also from them.
Yes, exactly, sir. Okay.
From them,
Okay.
from their children, from her children. Okay.
Deeply.
Item number 23.
Noren Boiragi, what is this? What is this Noren Boiragi? Anybody? Review. Anybody for the Noren? Who is the counsel earlier who was appearing? PC Day. PC Day, non-appears for the petitioner, list after a month. Next, yes.
Item number 24.
Nepal Das, anybody for Nepal Das?
Yes.
Yes, what happened to you, Nepal Das?
In this case, lordship, the writ petition was dismissed
On what ground?
without looking at the records, because on the threshold, the writ petition was dismissed. And the reference
What is the order?
order is at page, lordship, page
My lord,
69.
proceeding the case, my lord, the issue, my lord, primarily there was an issue in this case also, some delay was there, my lord. Your lordship was supposed to hear on that issue on 24th, other matters are fixed on 24th. Can this matter be taken along with that? Let the matter be discussed.
Okay, list on 24th. I read. 24th.
Yes.
Deeply.
Number 25.
Chittaranjan, yes, what is this?
I have filed one IA, my lord.
For what?
For, my lord, exempting from appearance before the superintendent board every 14 days. What happened, my lord, annexure A, my lord. This honorable court might order dated 3/4/2019 granted bail, my lord. Annexure A, my lord. And to appear before the superintendent police within 15 days and submit and furnish a bail bond.
Within 15 days.
That we appeared, my lord,
Then?
and bail bond has been submitted.
And then?
Now, thereafter, what happened, in terms of this order, my lord, the superintendent of police has directed him to appear every 14 days in a month. So whatever, he's a 68 years old, my lord. Now, every 14 days, he have to go there and have to sign.
But there is no such direction from this court.
Now, that's order, my lord, after the bail, my lord. This order, my lord, the next page, annexure B, my lord, last page. This
No, but then who is directed to appear before every 15 days? How can he add this condition?
that is the thing, my lord, he is 68 years old.
Mr. Payne, bail is bail, that he cannot add another condition.
2019 he is appearing, my lord, every month, my lord. That was the difficult.
There was no specific order from this honorable court.
Then,
My lord, in some cases, it is naturally, in most of the cases, the SPS has informed us. They, my lord, once the bail bond is submitted, they never appear before the SP, my lord, whenever search.
no, they can ask, as and when they feel they can ask, but then they are asking every 15, 14 days, maybe too much of a, this very, even the normal hardened criminals who are accused of raping and murder, dacoity, and they are not given such conditions are not imposed. Why this 68-year-old?
Paragraph 6 and 8, I have stated, my lord, paragraph 6 and 8.
As and when if they feel that yes, he can, if the always can ask, if the authorities feel that he is vanishing, he is trying to do vanishing act, but there is no such.
Let
Every
me get the
14 days.
instruction. Specifically in this case, let me get the instruction, my lord, if any is there. my lord.
No, my prayer is
Let me get
for,
the instruction within 1 week, my lord. If anything is.
Because you can't add, you can't add.
That is the.
Whether you are substituting the courts, you are taking over the role of the court. That is the idea also, because we don't know.
If there is any problem, my lord, let me get the instruction.
My lord,
within 1 week,
petitioner
my lord.
What problem you will have?
No, that's why.
Anyway, Monday,
Because,
later on Monday.
because my lord, not in all cases, this kind of is.
Okay, no problem. Let us see what this 68-year-old has done.
my lord.
But then see, you cannot suo moto impose this kind of condition, because that will be a dangerous precedent. Judicially, is a dangerous precedent if we allow this kind of condition to be imposed. If it is found to be unreasonable, we may impose cost on him also, please. But on that condition, we are allowing. So on Monday, if you find it the reason unreasonable, he may be visited with certain cost. Next.
2111. Supplementary list item 28 for us.
My lord, we have filed this review petition to review the order passed by learned single judge as usual division bench. The orders may be seen page 21 of the learned single judge. Here, my lord, the basic wrong, as I understand, subject to correction, there is a proceeding only against one person, that is Khadija Begum, ma'am. But whole.
What is the review order? Which order is you are seeking review?
Review that is both 21, page 21 and 21 and 21 and 15. 15 is the appellate order, page 15.
Well, this issue, this is also after long.
My lord, after long
Any will
time-
issue notice, we'll see.
No, my lord, kindly.
Notice, issue
No, my
notice.
lord, so many judgments I have.
Oh, we'll issue notice, we'll hear the other side also.
No,
First time, it has
that
come
may
for
be
the first
had,
time.
but, my lord, against inquiry is only against one person. But
We'll see
all-
that.
So, my lord, then the interim protection may be given. Police is
Inquiry,
behind
where
us.
is the inquiry? Where is the inquiry?
In my first order itself will say, my lord. that.
What is that? Why the document? you
Page
showed that?
85, can you see?
Page?
Page 85.
Inquiry against whom only? Page
Yes,
85.
that is there. Page 80, kindly see page 85. Relevant, kindly see, on receipt of the case on transfer of disposal from the Finance Tribunal, Nagao, it was registered in this tribunal above and notice was issued to Afi Mosammed Khadija Khatun, wife of so-and-so, her sons, Habibur Rahman and daughter so-and-so, notice was issued. Now, Lordship, kindly see the last portion, page 87, para 4.
Yes. Yes.
In the result, I am of the opinion that OP number 1 is an illegal migrant after so-and-so and as such he is a foreigner under section 2 A of the Foreigner Act 1946. Since the mother is a foreigner, the other office being the children of a foreigner mother are also foreigners under the same provisions of law, accordingly I declare. So, my lord, the proceeding was only against the mother. Now, the sons, children may have a better idea, better documents. Mother is illiterate totally. So, there was only proceeding against the mother. But the whole family members have been declared. My husband, Khadija's husband is already dead. She produced even the document of her grandfather, my lord, Akka Salim. So, my lord, I have a good case on merit. There is some mistakes on the part of the petitioners, but that mistake would not make them foreigner. So, when, my lord, so many judgments I have, for instance, my lord, I do a lost him kind of in case of Bashanti Vishwas, that is reported in 2019, 1 GLT 363. It is clearly held by the division bench of this High Court that if a person is declared as a foreigner, then his children automatically does not become foreigner. There should be separate. Your lordship has also similar so many judgments. And then in case of Kalpana Saha, it is also said that the descendants, it is a case of WPC number 5716 2019, page order dated 10/8/22, comprising your lordship. This is your lordship's order, along with my lord Justice Soumitra Soikia. So these are the orders. Kindly see here. Everywhere it is said that if a person is declared as a foreigner, his sons and daughters does not become foreigner. There should be separate inquiry. No inquiry. All persons are adult and over and above, my lord. Just most important thing is this: all my relatives, my brothers and sisters' names have been recorded in an NRC. Kindly see page 792 onwards. Page, sorry, my lord. Kindly see page 89 onwards. This is Moriam Nessa, daughter of Khadija Khatun, page 89. Her name is recorded in NRC. Page 90 is the NRC's heir number. Then lordship, kindly see page 91. Yeah, Habibur Rahman, he is one of the petitioner here. His name has been also recorded in NRC after thorough verification by the NRC authority. Then page 92, Minara Khatun, one of my sister. One of the sister of Habibur Rahman. Her name is recorded in NRC, page 93, the NRC ARN number. Then lordship would see that Khadija Khatun, her own name has been recorded in NRC. Actually, tribunal took some matters, photocopies. Photocopies, I admit, but that was the improper conduct of the case by the learned counsel. When we have got original copy, he should have been submitted. My humble prayer is only this, my lord. We have a very good case on merit and so many judgments of Honorable Apex Court as well as your lordship's order that in such a case, when there is a proceeding only one person against and all the family members cannot be done, my lord. There we are living in a society guided by law, not guided
Yes,
by...
Mr.
My lord, first of all, my lord, the impugned opinion, first opinion also 2010. Then this honorable court in the writ petition, my lord, in 2014. Then this appeal was dismissed in 2017. Now after 7 years, my lord, 6 years, they are approaching before this honorable court.
No, we earlier filed a petition, my lord, that was withdrawn due to some, it was observed that
my lord,
some
matters, my lord, the reviews are coming, my lord, the reviews are allowed or reviews are filed, my lord. The very purpose of the entire purpose, in fact,
what purpose?
he should have been.
A person is not a foreigner, making him or her foreigner, that is the purpose. My only humble
lord-
prayer, my lord, I may be granted privilege of bail and let the matter be heard. We will argue on this, so many judgments we do have. Kindly protect us, my lord. And matter may be heard. My learned friend will be prepared. I shall be also prepared.
First of all, my lord, whether it is maintainability of this petition itself is.
What maintainable?
Maintainable,
Yes,
then your
my lord.
lordship may
It is
protect.
maintainable.
Let the maintainability of the.
Yes,
issue-
2005 for
maintainability issue
SCC,
may
I have a report, I am submitting, my lord. 2005 for SCC, 741, my lord. Para 80, 8, 89 and 90. I may, if your lordship kindly permit me, I may read. We are furthermore of the opinion that the jurisdiction of the High Court in entertaining.
Okay,
any-
we are issuing notice. We are issuing notice. Maintainability also will be considered.
Will
Hard,
be
Mr.
considered, but-
Hard, Mr. Learned Counsel for the issue notice over 3 weeks. The maintainability, the Learned, Mr. Payang has raised objection on the maintainability repetition that will be considered on the next September day. To stop. It has been submitted now that in the meantime, he may be, that she may be given protection in.
They may be, my lord.
They may be, in the petition may be given protection in as much as sufficient documents to show that they are Indians, not foreigners, which however could not be properly appreciated, placed before the tribunal, oblique high court, which could not be properly appreciated. We have also, having heard learned counsel for the parties, in the meantime, the petitioners have not been detained on the strength of the so, they may be allowed to remain on bail.
My lord.
It is not detention, my lord. In fact,
If not already detained.
No, not detailed. You are outside.
they has to be deported, in fact, after this order.
Mr. Payang, they were to be deported in 2010.
After 2007.
And you are sitting over it.
You took some sleeping
Yes,
pill.
My lord have.
You
rightly
took some
pointed out.
sleeping pill and you slept off. Then you woke up like.
Because they know we are not foreigner, that is why.
They are giving
Is
a
a-
chance to file.
There are
If you had deported them at that time, they would be screaming, shouting in Bangladesh, and Bangladesh High Court or somewhere, not in before the Guwahati High Court.
My lord, the relation between India and Bangladesh is very good,
Okay.
but no, they are not discussing this. That is political.
Next.
Daily list,
My lord, I am sorry, my lord, my item was 23, my lord, review petition. My lord, may I pray, my lord, to take this matter? I'm sorry, my lord, I am could not make up the time.
What happened in 23? I don't know. Or gone. What happened in 23? Gone. Oh. What is there in review petition?
Review petition, my lord. Same, my lord, my learned friend has done this case. Similar though. My lord, one document I have, problem is that, my lord, I have stated in the WS that I have casted my vote along with my father. But I could not submit the documents. As I could not collect the certified copy. Subsequently, my lord, in the High Court, I have declared by the Foreigners Tribunal as a foreigner. I have approached this honorable court, and this honorable court, I have submitted the voter list of 1993. That
Item number? Yours is item
item
number?
number 23, my lord.
20. Noren Boiragi.
Noren Boyagi, my lord.
Boiragi.
My lord, same issue is there.
Huh?
Same issue is there, my
Oh, I
lord.
see.
The petition was disposed of in 2017.
Boiragi, roaming around. You have been roaming around. Boiragi.
My lord,
Let it
My lord,
come 24. and then
You
other
have been
matters.
roaming around since 2017, Boiragi. Boiragi, Tyagi, they are all renounced.
my lord. Subsequently, my lord, I have obtained the certified copy of the voter list and I have produced before the division bench, but it is not considered. And that's why, my lord, the review petition. my
Same, Mr. Okay.
Same, let it come on 24 first, my lord, then we will go on merit if it is.
And my lord, not only the petition has been declared, those are not parties.
24 TLB.
The same issue is there, my lord, 24, same issue, whether, my lord, the review after 4-5 years is maintainable, that issue may be decided first. Then, my lord, we can go on merit.
No, my lord,
The
I have,
review-
in this case, I have approached the Supreme Court.
Have you issued notice? No, noted.
My
Notice
lord-
have been already issued or no?
My lord,
Item number 23.
motion,
Your motion,
call for records and records has been received. My lord.
notice was issued or what? No.
Notice, my lord,
Noren Boiragi.
Noren Boyagi, my lord.
Notice was issued or what?
Well, the notice issue, the call for record was called for, my lord, by the order 8/8/2022.
Okay, Likho, Han Mr. Lane Council for the review petitioner issue notice renewal 3 weeks. By order, as per order dated 8/8/2022, notice have been called, records have been called for and which have been received. According the matter can be heard. In the meantime, if the petitioner has not been detained on the strength of the petition.
Item number 26, stay matters.
What stay matter? Minoti Bala. Who is for Minoti Bala? Record is it?
System. Record is.
On the prayer of G. Sharma, FT,
Record.
stand. A. Das, petitioner. A. Das, petitioner. What is this? This is a stay what? Stay of what? Stay matter. Already stay.
There is an stream order.
Then why is stay order? Oh. Okay. Already stayed, huh? Past validity. By order, the issue release had called for records and state the impugn. So, a long time back it was stayed, huh? Record have received. You will place for hearing then in that case.
Yes.
Since the records have been received, record have been received.
Record is there, man.
Where is the record?
It is. It is.
Oh, with you?
Yes.
Oh, I see. Since the records have been received, the matter can be fixed for hearing, for final hearing. This accordingly for final hearing.
Record is returned back.
Okay.
That may be no.
The records which was kept, which was handed over to the Mr. Pine, has been returned. Oh, okay, Mrs. G. Sharma. Earlier handed over to G. Sharma has been returned. What do you want? Tell us.
That's it. 1 week time. We need.
Actually, we have filed an additional affidavit today,
Yes.
bringing on record some recent developments in the form of some orders passed in connection with the present arbitration petition, which will help this honorable court to decide the issue at hand.
Okay.
So today they have been served a copy. They wanted to take some time, my lord,
Okay.
to obtain it.
So when should it come up?
Why not as per your lordship convenience, but if not inconvenient for my lord, can it be on next week, my lord?
Next week?
Next week.
Okay. List again on so and so on the prayer of Mr.
Archetri.
Archetri.
23/11.
I'm deeply obliged.
Twenty. 5/12. 5/12.
Okay.
Fifth. Daily list for admission, item number 1 to 3.
Lordship, this matter is part hard. Our part has been over. It was their turn to give the replies.
Yes.
My lord, item number.
One, two.
Well, item number 1 and 2, my lord. 1, 2, and 3, my lord. In this matter, my lord, Mr. B. Sharma will argue, my lord. And my matter is, my lord, right turn engineering, item number 4, my lord.
Lordship,
And
the
one more
first
is here, my lord.
1 to 3 is stacked. 4 is
And my
I think
lord,
it's not.
And 8, item number 8, my lord. My lord, Mr. R. Hussain is here, my lord. But these are similar matters, my lord. So, my lord, may I start, my lord? By the time, my lord, my friend has informed me that he will come.
You are saying something?
Lordship, 1 to 3 was tagged. The other matters are not tagged with 1 to 3.
Okay, and in 1, 2, 3, who is going to appear?
Lordship,
Please,
only 1, I think B. Sharma was appearing,
Madam,
and 2
not tagged,
and
madam.
3, Madam was appearing.
My lord, I'll start, my lord. Because, my lord, all the matters, my lord, the issue is same, my lord. Whether, my lord, railway can appoint its own arbitrator or not, my lord. Where, my lord, Mr. Goswami has asked. So, my lord, I'll place, my lord, one judgment, my lord. That is, my lord,
Just a minute, huh? Just a minute.
আরেকটা আছে না এটা লাগে এটা
Before we hear your submission, is there any matter which one notice is required to be issued or something like that? Others also require hearing? Any matter where notice is to be issued or something like that? In any matter, because this will take some time once we start the hearing.
Item number 6.
6,
Already your lordship has had on 3 dates.
no,
And now it's fixed for order, I suppose.
okay, no, that is okay. We'll hear. Any other item where perhaps notice is to be issued or something like that? Item number 10, SR engineer, huh?
My lord, item number 8, my lord.
Item number 8 also has to be argued the other
No,
side.
my lord, in this case, they have filed the additional affidavit and I am going to file the reply within 3 days.
Item number 8.
8, my lord.
Okay. In that case, Likho, you'll have to file a reply.
Against the
Mr.
additional
R.
counsel.
Hussain, Lane Council for the petition submission, he would like to file a reply to the additional affidavit filed by the railway authorities. List accordingly on when?
Next week.
5 sir 5 now Ganga construction 5 to go here.
Item number 5, sorry.
Item number?
5,
In 5,
5, my lord.
not in 8.
Not in it. sorry.
Okay. In item number 5, huh? Then any other matter where notice has to be issued or?
And my lord,
date has to be
this
fixed?
item number 13, my lord.
Huh,
State government is appearing, my lord. They have not filed the counter affidavit till date, my lord.
arbitration,
Yes. So last chance may be given for that.
okay. In item number 13, who is
13,
appearing to a standing counsel PWD?
Mr. Chaudhary appeared earlier.
It will be appropriate if he is present, then he would
Yes.
know.
So we will wait for some time.
Uh-huh. Any other item where perhaps notice is to be issued? It will not require a lengthy hearing, because we'll once he takes up this hearing. Okay,
I talked to railway council. Railway council said that this is fixed for judgment, so you can wait till judgment is passed.
because these are also similar issue, no? So let us.
So item number 6.
Item number 6, okay. Yes, Mr. Usman.
My lord,
You are arguing in item number?
my lord,
You are arguing in item number?
4. My lord, 4.
Raitani.
Yes, 4 and 8, my lord.
8 my lord right now they have mentioned 1 to 8.
4 and 8, na?
Yes.
I think that the petitioner
8,
petitioner
8, 1.
And 1, 2, 3, who will be arguing?
1 to 3 we are for the petitioner.
Correct, you are for the petitioner. And 1, 2, 3, who is supposed to argue? Mr.
B, sir, my lord.
B. Sharma. So Mr. B. Sharma will argue. Okay, because you are,
Lordship only 1 he was handling. I think 2 and 3 madam was handling.
but madam
It
is
is the-
relying on B. Sharma.
Yes. Yes.
They can rely, they can
Similar matter.
cooperative, they can cooperate.
Lordship actually similar matters.
That is why.
Yes.
Parties are also similar.
Party is also similar.
Party also similar.
Yes. Lordship.
Okay. So you'll be in Raitani.
Yes, my lord.
Raitani, Jane has argued or what? I don't know.
Jane actually is the out of station lordship.
But has she argued? I don't know.
Already.
My lord, some arguments he has made, my lord, earlier, my lord, but probably she will make some more argument, my lord.
So you'll be arguing on item number 4 and 8.
8, my lord.
In item number 8, Mr. Hussain is there. You have already argued.
This case I have not argued, but in other cases I have argued and I have referred so many cases of.
But the same.
Same, only Bhanumati case they are relying on.
Bhanumati.
Yes. So only their argument is based on that judgment.
Okay,
So my lord, I'll place that on that judgment only, my lord.
okay, okay.
Almost my lord, point is only one. Then the facts are different, certain difference with argument.
Yes,
So my lord, on the other day, my lord, when my lord, the learned counsel argued, my lord, his main trust is on, my lord, that this judgment, my lord, reported in 2020 14 SCC, case 712, my lord, Central Organization for Renewable Electrification versus PCI SPIC JB. This is my lord, is par incurium and passed in sub silentio. Due to the fact that my lord,
you had relied on central organization, isn't it? Huh? So you want to rely, you want to submit on central organization, isn't
exactly.
it?
And my lord, after my lord, my lord, that amendment was, my lord, amendment was brought, my lord, brought in, my lord, in 2015, my lord.
Yes,
Amendment was brought in, my lord. There, my lord, the railway has, my lord, passed a notification, my lord, whereby, my lord, the constitution of, my lord, in order to, my lord, accommodate the amended section, my lord, the
so after amendment was made in 2015,
15, my lord,
the railways brought in what?
the notification, my lord. One notification, my lord.
Have you mentioned anywhere this notification?
Yes, my lord. That notification, my lord, it is relied by this judgment also, my lord. 2020 14 SCC, my lord.
Do you have the copy of the notification
Yes,
in the
ma'am.
pleading?
Yes, in the pleading, not in the pleading, my lord.
Then can you give a copy
My
of
lord,
that?
my lord.
Unless it is already given.
My
Huh?
lord, my lord.
Lordship, we have once hand over the.
You have handed over the notification. I'll just check. I'll just check the document. Amendment. This one.
Lordship, 2016. 16 notification.
6/11/2016.
Yes, Lordship.
This one. Are you referring to this?
11th November 2016, my lord.
16 November. Huh?
My lord, 11 November 2016, my lord.
11 November.
Yes, my lord. And lordship will.
11. I have
16.
16
My lord, 16
November.
November, my lord, that's 16 November, yes. My lord, 16 November, my lord. 16 November, my lord, exactly, my lord. 16 November 2016, my lord. And my lord, that is, this notification is, my lord, precisely mentioned in the judgment, my lord, we are relying on, my lord.
Is it the same one? Just have a look.
Yes, ma'am.
And what is this 11 November?
My lord, actually, this is the main notification, my lord. Some amendment was brought, my lord, which were by mistake, my lord, it is written here, my lord, subsequent to the promulgation of Arbitration and Consolidation Amendment Act 2015, clause 64 of the General Condition of Contract has been modified by Railway Board letter referred above, my lord. That is, my lord, 11 November 2016, my lord. However, during the issue of letter, the draft copy of annexer regarding format of certification of by arbitration was inadvertently enclosed, my lord. To item number 8 of the said annexer stipulates regarding certification by arbitrator to conclude the arbitration process within 27 months. 27 months, that is arbitration process 24 months and rendering award 3 months as against 12 months. In view of above, said annexer is cancelled, my lord. The annexer is only cancelled, my lord. The original notification was published in 11 November 2016. Some modification, my lord, is made, my lord. That is, my lord, the notification.
So what has been cancelled?
My lord, it was stated there, my lord, that the total, my lord, time frame for conclusion of arbitration proceeding, my lord, is, my lord, 27 months, my lord.
That has been cancelled.
My lord, that, my lord, that only that part, my lord.
Okay.
There are, and it is stated that here that it, due to inadvertence, corrected, my lord. It is corrected, my lord. So, my lord, the bone of contention is this notification, my lord. Here. এতিয়া নাই,
Yes.
and my lord, there is no silence to this notification also, my lord.
Yes, this notification 1611 has not been. And what is in 1611?
1611, my lord, to accommodate the amended section, my lord.
Huh?
My lord,
So what does it provide? Amendment, this notification that 11/11/2016.
yes, my lord.
In view of the promulgation of the Arbitration Consolidation Act, it has been decided by the board to modify clause 64 of the Indian Railways General Conditions Contract as under follows.
My lord.
So what is being modified? It was modified
That,
with effect from 11/11/2016 perhaps.
my lord.
Huh?
My lord.
Now, question is, now, okay, 64(1), then the parties may waive off applicability to
My
sub.
lord, two things here. It
Yes.
said, my lord.
Yes,
My lord, if, my lord, they waive off that condition,
yes,
railway of serving railway officer cannot act as an arbitrator.
Hmm.
Then, my lord, the serving railway officer will act as an arbitrator, my lord, if they waive off. There is a waiver provision also, my lord. Lordship will find, my lord. It is, my lord, in my lord 11:20. My lord, 12:5, my lord.
yes.
My lord, section 12 subsection 5, my lord. My lord, may I read?
Yes.
Notwithstanding anything prior agreement and any prior agreement to the contrary, any person whose relationship with the parties or counsel or the subject matter of the dispute falls under any of the categories specified in 7th schedule shall be ineligible to be appointed as an arbitrator. So, my lord, previously, my lord, there is provision of, my lord, serving railway officer, my lord. Here is a proviso, my lord. Provided that the parties may subsequent to the dispute having arisen between them waive the applicability of this subsection by an express agreement in writing. So if my lord 12(5) is waived off, then my lord this earlier agreement will apply, my lord. That to the effect that serving railway officer will act as an arbitrator. But if it is not waived off, my lord, that provision has been brought in by this notification, my lord. And my humble submission is that, my lord, this notification is, my lord, published only to accommodate the amended section, my lord.
So this notification dated 11/11/2016,
My lord.
it incorporates the provisions of section 12(5). That is one. That is your case, huh?
Yes. Here, my lord, contention is that you cannot publish such document. And, my lord, second is that in this, my lord, the judgment of the Honorable Supreme Court, my lord, which we were relying upon, my lord, their submission is that point is not argued. So, my lord, this judgment cannot be whole as ratio decision.
See,
It
only
is-
only thing that Mr. Swami. Okay, this notification 11/11/2016. Now, by virtue of this, now the changes made in arbitration consolidation also have been incorporated
Yes, my
in your GCC, isn't it? Huh?
lord.
Like, for example, demand 64(1), there is no change.
My lord.
64(1)(2)(a), also there is no change perhaps.
My lord.
Then change have been brought in 64(1)(2)(b).
My lord.
Huh?
Arbiter.
The parties may waive off the applicable section of the arbitration if they agree for such in writing after arising
Exactly.
in the format given annexure.
And, my lord, 64(3)(c)(2).
Ha. And the 64
3
3 appointment arbiter where applicable has been waived.
Right.
Now, is there any waiver by any of the parties? Because this also provides a waiver. Otherwise, you cannot do on your own.
My lord.
There cannot be unilateral imposition.
My
Huh?
lord.
It has to be waived by both the parties.
My lord.
In this case, in a particular case before us,
No, my lord. We
has
have
it
not
been waived?
Not waived, my lord.
If it is not waived, then this section
My
this
lord, that will not come. The subsequent, my lord, provision will come.
which section of provision? What is the subsequent provision? If you don't waive, then what will happen?
Waived off.
If there is a waiver, then there is no problem. Then you can always appoint an arbitrator from the panel maintained by you. But if there is no waiver by express agreement, then what will happen?
My lord, then my lord, return or provision of a list, my lord, of retired arbitrator will be sent to the my lord, claimant, my lord, and they will choose one arbitrator of their choice, my lord, and my lord will appoint another, my lord,
But then
and the
retired also is come under the bar, no?
No.
Had
that is not part.
notwithstanding anything, under any person whose relationship with the parties falls under any of the categories, especially 7th schedule. Let us see 7th schedule.
My lord, 7 schedule, yes. my lord.
Yes.
Seventh schedule, arbitrators' relationship with the parties or counsel. The arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with a party.
Advisor or has any other past or present business
Business
relationship.
relationship with
Ah.
parties. The arbitrator currently represents or advises one of the parties or an affiliate of one of the parties. The arbitrator currently represents the lawyer or law firm acting as counsel for one of the parties. The arbitrator is a manager, director, or part of the management, or has a similar controlling influence in an affiliate of one of the parties if the affiliate is directly involved. This is also not applicable, madam. The arbitrator's law firm had a previous but terminated involvement. This is not applicable.
See, number one, the arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the party.
Right.
Even that you mean to say that an employee,
Madam.
an employee doesn't have a past relationship with the ex-retired employee,
Right.
is not covered by clause 1.
But my lord, I am not saying, madam.
Then?
This is by the Honorable Supreme Court, my lord, by 2 or 3 judgments, I'll test it. Where my lord, it was hold that retired employee can act as an arbiter.
On what basis?
Or my lord,
Okay, okay.
I'll refer to that.
So this 11 November 2016,
My lord,
which we are trying to rely,
my lord,
it does not show anything new.
my lord.
It is just incorporates what section 12(5) says.
Exactly,
Huh?
my lord.
So under section 12(5), unless the waiver is by way of express agreement,
My lord.
the waiver that therefore that the bar contemplated under 7th schedule will come into play,
My lord.
isn't it?
My lord.
So why you are relying on this November 16 notification?
Because my lord, this notification provides for appointment of my lord, pool of arbitrator, my lord, where my lord, retired officers are given, my lord. We have, my lord, 2 lists of arbitrators, my lord. One are serving relay officers, my lord. If my lord 12(5) is waived off, my lord, then my lord, the first list will operate, my lord. If my lord, it is not waived off, my lord, then my lord will send the second list, my lord.
What is the second list?
My lord, here.
Oh,
My lord, I'll read this as well. My lord, I'll show it from this as well, my lord. My lord, now, my lord, I'll my lord, read some of the parts of this as well, my lord.
yes. That central organization. no?
Yes, central organization.
Yes. Para number?
My lord, para 2. Page 117, 717, my lord. May I read, my lord?
You are reading from which citation?
My lord, SCC, my lord.
SCC, just one. Yes.
Para 2, my lord. I'll start from para 2, my lord.
Mhm.
The appellant awarded work contract of rupees 165 crore 67 lakh 98,570 to the respondent company by an agreement dated 29/2010, my lord. This date is important, my lord, because the agreement was signed, my lord, before
Yes.
coming up with the amended section, my lord, into 2015, my lord, because this is of 2010, my lord, which contains the arbitration clause. Subsequently, after coming into force of Arbitration and Conciliations Amendment Act 2015, with effect from 23/10/2015, the Government of India, Ministry of Railway, made a modification to clause 64 of the General Condition of Contract and issued a notification dated 16/11/2016. My lord, that is the notification, my lord. So, my lord, it has, my lord, discussed this 16, the notification, my lord. And, my lord, it has also mentioned that the contract was signed, my lord, before, my lord, and before the amendment. And, my lord, this notification was brought in after the amendment. So, my lord, the Honorable Supreme Court was conscious, my lord, that this notification was brought in, my lord, after the amendment, my lord. So, my lord, their argument that this has not been considered, my lord. This argument has not been considered, that the amendment was brought in later on. That is why it cannot, my lord, it cannot be accommodated into the contract agreement which was signed earlier, my lord. Their submission is that, my lord. Because this notification was brought in subsequently, it cannot, my lord, we cannot rely upon this notification to the my lord, contract agreement which were signed, my lord, before 2015, my lord, or my lord, 2016. Because, my lord, the Honorable Supreme Court has categorically stated that contract agreement was signed in 2010, the amendment made was 2015, and the notification was brought in into 16/11/2016 for implementation, my lord. This line is very important, my lord, for implementation of the notification, my lord. So, my lord, this was allowed, my lord. The modification modified clause 64(3)(a) Roman 2, where applicability of section 12(5) has been waived off. Inter alia provide that in case where the total value of all claim exceed 1 crore, the arbitral tribunal shall consist of a panel of 3 gazetted railway officers, not below junior administrative grade, or 2 railway gazetted officers not below J grade, and a retired railway officer, retired not below the rank of senior administrative grade officer as arbitrators. So, my lord, there are provision of 2 serving officer, 1 retired officer, my lord, earlier, my lord. The procedure for constitution of arbitral tribunal is provided there. The clause 64(3)(b) deals with the appointment of arbitrator where applicability of section 12(5) of Arbitration and Conciliation Act has not been waived off. Clause 64(3)(b) stipulates that the arbitral tribunal shall consist of a panel of 3 retired railway officers, my lord, not below the rank of senior administrative officer as the arbitrator as procedure indicated there on. Since the respondent did not complete the work under the contract within the prescribed period of 18/10/2017, the appellant issued 7 days notice under clause 62 of General Condition of Contract to the respondent. Hereafter, on 27/10/2017, the appellant issued a 48 hours notice to the respondent, calling upon the respondent to make good the progress of work, failing which the contract will stand terminated. Since the respondent did not make adequate progress in the work on 1/11/2017, the contract was terminated as per clause 62 of General Condition of Contract. The respondent was also informed that their security deposit has been forfeited, and the performance guarantee submitted by it shall also be encased. The respondent filed petition number 760 of 2017 before High Court, challenging the termination of the contract, which came to be dismissed by the High Court, had order dated 28/11/2017, and the High Court directed the respondent to avail the alternative remedy by invoking arbitration clause. The respondent, by its letter dated 27 7/2018 requested the appellant for appointment of arbitrator. So the arbitration clause was invoked, my lord, after in 2018, my lord. Here in my case also, my lord, the arbitration clause was invoked in, my lord, after subsequent to, my lord, the amendment, my lord. Resolving the dispute between the parties and settle the claims value of rupees 73.35 crores. In reply dated 24/9/2018, the appellant sent a list of 4 serving railway officers, serving railway electrification officers of J grade to act as arbitrator. The respondent was asked to select any 2 and communicate to the appellant for formation of the arbitral tribunal panel. File letter dated 25/10/2018, the respondent was sent a list of another panel comprising 4 retired railway officers in terms of clause 63(3)(b) of Railway's general condition of contract, my lord, which is, my lord, brought in subsequently, my lord. The respondent was asked to select any 2 from this list and communicate them to the appellant within 30 days for constitution of the arbitral tribunal. The respondent did not send a reply to the above letters of the appellant, but filed arbitration petition 151 of 2018. The High Court under section 11(6) of the Arbitration and Consolidation Act seeking appointment of a sole arbitrator for resolution of differences. In its petition, the respondent suggested the name of one Sri Ashwini Kumar Kapoor, retired member of electrical from Railway Board, to be appointed as an arbitrator in the matter. According to the respondent, there exists a valid and binding arbitration clause between the parties, being clause 1.2.54 of part 1 so and so chapter so and so, and also clause 64 of general condition of contract. But since no neutral arbitrator is contemplated to be appointed in the general condition of contract, the respondent has no other recourse except by filing the petition under section 11(6) of the Arbitration and Consolidation Act 1996. So, my lord, there is no independent arbitrator. These are all railway employees, either retired or, my lord, serving, my lord. The High Court, by the impugned order dated 3/1/2019, rejected the argument of appellant that the arbitrator ought to be appointed only from panel of arbitrators in terms of general condition of contract. The High Court observed that the power of court to appoint arbitrators are independent of the contract between the parties, and no fetter could be attached to the power of the court. With those findings, the High Court appointed Sri Rajesh Dayal Khare, a retired judge of the Allahabad High Court, as the sole arbitrator, subject to his consent under section 11(8) of the Arbitration Act. Subsequently, by order dated 29/3/2019, the High Court noted the consent of the arbitrator appointed by the court and directed the arbitrator to proceed with the arbitration proceeding. Being agreed, my lord, the appellant has preferred this. Mr. A.N.S. Natkani, the learned additional solicitor general, appeared for the appellant, submit that the terms of the clause, my lord, here also, my lord, railway has approached, my lord, the Honorable Supreme Court, my lord, that in terms of clause 64(3)(a) Roman 2 of the general condition of contract, where applicability of section 12(5) of the panel of 3 gazetted railway officers not below the junior administrative grade, or 2 railway gazetted officers not below junior administrative grade, and a retired railway officer retired not below the rank of senior administrative grade officer as arbitrator. It was submitted that as per clause 64(3)(b) of the general condition of contract, where applicability of section 12(5) of the Act has not been waived off, the arbitral tribunal shall consist of a panel of 3 retired railway officers, retired not below the rank of senior administrative grade officer, as the arbitrators, after compliance of the procedure stipulated in 64(3)(b). It was contended that when the agreement and the general condition of contract provide for appointment of the arbitral tribunal consisting of 3 arbitrators from the panel, the High Court erred in appointing the sole arbitrator outside the panel of arbitrator. The learned ASG further submitted that the appointment of an independent arbitrator is contravention of clause 64.3A1, clause 64.3A Roman 2, and clause 64.3B of the general condition of contract, and impugn judgment appointing former judge of the High Court of Allahabad is not sustainable. In support of the contention, the learned as a inter alia pleaded place Union of India former concession and others. Refuting the above contention, Mr. Sridhar Pattaraju, learned counsel for the counsel appearing for the respondent, submitted that the Arbitration and Conciliation Act 1996 was amended with effect from 23/10/2015. And in the present case, the demand for arbitration for resolution of dispute was made by the respondent on 27/7/2018. Hence, the provision of amended act apply to the hence provision of the amendment act apply to the present case. It was submitted that by virtue of provision of 12.5 read with Schedule 7 of the Arbitration and Conciliation Act 1996, the panel of arbitrators proposed by the appellant filed letter dated 24/9/2018 was statutorily made ineligible to be appointed as arbitrators since they were either serving or retired employee of the appellant. It was contended that as per the provision of Amendment Act 2015, all employees present or past, my lord. The question, same question, lordship has been, my lord, just now, my lord, has raised, my lord. Present or past are statutorily made ineligible for appointment as arbitrator. Mr. Pattaraju, learned counsel, further submitted that when the general manager himself being ineligible to be appointed as an arbitrator under section 12.5, read with Schedule 7 of the Act, general manager cannot nominate any of the person to be arbitrator. The learned counsel for the respondent inter alia placed reliance upon Simnen GmbH versus Delhi Metro Rail Corporation Limited, TRF Limited, and TRF Limited versus Energo Engineering Project Limited, and a number of other judgments which would be referred to at the appropriate place. We have carefully considered the submission and perused the impugned judgment and materials on record. The point falling for consideration is whether High Court was right in appointing an independent arbitrator in contravention of clause 64.3A Roman 2 and 64.3B of the general condition of contract. Now, appointment of an independent arbitrator without reference to the clause of general condition of contract GCC, whether correct. The learned counsel for the respondent submitted that being serving employee of appellant, the panel of arbitrator proposed by the appellant, filed letter dated 24/9/2018 were not eligible to be appointed as arbitrator in view of the provision of section 12.5, read with Schedule 7 of the Arbitration and Conciliation Act. The learned counsel further submitted that the panel of arbitrator proposed by the appellant, filed letter dated 25/10/2018, comprising of retired employee of the appellant, were also not eligible to be appointed as arbitrator under section 12.5, read with Schedule 7 of the Act, as the employee of the appellant are expressly made ineligible. In support of the above mentioned consideration, learned counsel for the respondent has placed reliance on this decision, my lord. We'll skip this portion, my lord.
Yes.
My lord, now I'll come to my lord, para 14, my lord.
Yes.
My lord, before that, my lord, I'll read out 2 lines, my lord. Top of para 14, my lord. The only way in which the ineligibility can be removed again in law is that the parties may, after dispute have arisen between them, waive the applicability of subsection by an express agreement. My lord, that is they have argued that point, my lord. And my lord, my learned friend is also relying on the same ground, my lord. That only way is that, my lord, if they waive the my lord. There is no other way. Par contra, on behalf of the appellant, Mr. ANS Narkari Laneka, they has submitted that the appointment of arbitrator is governed as per clause 64.3A1 and 64.3A Roman 2 of the general condition of contract, where applicability of section 12.5 of the Arbitration and Conciliation Act has been waived off, and the arbitral tribunal shall consist of a panel of 3 serving railway officers or 2 serving officers and 1 retired officer, the learned ASG submitted that the clause 64 3B of the GCC deals with appointment of arbitrator where applicability of section 12(5) of the Act has not been waived off. It was further submitted that the clause 64 3B of GCC stipulates that the arbitral tribunal shall consist of a panel of 3 retired railway officers not below the rank of senior administrative officer, and the arbitral tribunal to be constituted as per the procedure indicated thereon. Placing reliant upon the formal construction and others, the learned ASG has submitted that when the agreement specifically provides for appointment of panel or arbitrator, the appointment should be in terms of the agreement, and the appointment of independent sole arbiter is in contravention of general condition of contract, which governed by parties for appointment of arbitrators. Now, my lord, para 16, my lord, it is, my lord, how, my lord, the GCC, what GCC said, my lord. Clause 64 of general condition of contract, my lord. Clause 64(1), demand for arbitration. In the event of any dispute or difference between the parties hereto, as to the construction of operation of this contract or the respective right and liabilities of the party on any matter in question, dispute or difference on any account, or as to the withholding by the railway of any certificate to which the contractor may claim to be entitled to, or if the railway fails to make a decision within 120 days, then and in any such cases, but except in any of the accepted matters referred to in clause number 63 of this condition, the contractor after 120 days, but within 180 days of his presenting his final claim on disputed matters shall demand in writing that the dispute or difference be referred to arbitration. 64(1) Roman 2A, the demand for arbitration shall be specified the matter where, my lord, I'm skipping, my lord, this part, my lord, how the demands can be made, my lord. Para 16, my lord. After coming into force of the Arbitration and Consolidation Amendment Act 2015, the Government of India Ministry of Railway made a modification to clause 64. So, my lord, it is discussed here, my lord. Clause 64 of General Condition of Contract and the Railway Board issued notification dated 16/11/2016. In this regard, the modified clause 64 3A Roman 1, where applicability of section 12(5) of the Act has been waived off, inter alia provides that in case where the total value of all claims in question added together does not exceed 1 crore, the arbitral tribunal shall consist of sole arbitrator, who shall be gazetted officer. My lord, I am skipping one line, my lord. In present case, since the value of the contract is worth more than 165 crores, clause 64 3A2 is not applicable. So one, my lord, officer is not applicable. Para 17, clause 64A2 of the GCC deals with cases not covered by clause 64 3A Roman 1, where applicability of section 12(5) of the Act has been waived off. Clause 64 3A2 of the General Condition of Contract read as under. My lord, this is the, my lord, amended provision, my lord, which is applicable in our case, my lord. Appointment of arbitrator 64 3A Roman 2. In case not covered by clause 64 3A Roman 1, the arbitral tribunal shall consist of a panel of 3 gazetted railway officers not below Z grade or two railway gazetted. Here also, my lord, if my lord, it is more than, my lord, 1 crore, then also, my lord, provision of my lord, serving railway officers was given, my lord. Z grade of 2 railway gazetted officer not below Z grade, and a retired railway officer retired not below the rank of SAG officer as the arbitrator. For this purpose, railway will send, my lord, this is also not applicable for us, my lord. The next para, my lord. Clause 64 3B of GCC deals with the appointment of arbitrator where applicability of section 12(5) of the Act has not been waived off. The modified clause 64 3B inter alia provide that the arbitral tribunal shall consist of a panel of 3 retired railway officers not below rank of SAO officers as arbitrator for this purpose. The railway will send a panel of at least 4 names of retired railway officers empaneled. The contractor will be asked to suggest to the general manager at least 2 names out of the panel of panel for appointment as the contractor's nominee, and the general manager shall appoint at least 1 out of them as the contractor's nominee. The general manager will also simultaneously appoint the balance number of arbitrators from the panel or from outside the panel. The modified clause 64(3)(b) of the Gazette General Condition of Contract reads as undermined. This is the modified clause, man. The appointment of arbitrator where applicability of section 12(5) of the Arbitration and Consolidation Act has not been waived off. The arbitral tribunal shall consist of a panel of 3 retired railway officers, retired not below the rank of SA officer, as the arbitrator. For this purpose, the railway will send a panel of at least 4 names of retired railway officers empaneled to work as railway arbitrator, indicating their retirement date to the contractor within 60 days from the day when a written and valid demand of arbitrator is received by the GM. Contractor will be asked to suggest to general manager at least 2 names out of the panel for appointment as contractor's nominee within 30 days from the date of the dispatch of the request by the railways. The general manager shall appoint at least 1 out of them as contractor's nominee and will also simultaneously appoint the balanced number of arbitrators either from the panel or from outside the panel, duly indicating the presiding officer arbitrator. From amongst the 3 arbitrators so appointed, the GM shall complete this exercise of appointing the arbitral tribunal within 30 days from the receipt of the names of the contractor's nominee. While nominating the arbitrators, it will be necessary to ensure that 1 of them has served in the accounts department. After coming into force of the Arbitration and Conciliation Amendment Act 2015, when clause 64 of General Condition of Contract has been modified, inter alia providing the constitution of arbitral tribunal consisting of 3 arbitrators, either serving or retired railway officers, the High Court is not justified in appointing an independent sole arbitrator without resorting to the procedure for appointment of arbitrator as prescribed under clause 64(3)(b) of the General Condition of Contract. It is pertinent to note that even in the application filed under section 11(6) of the Arbitration Consideration, the respondent prayed for appointment of a sole arbitrator in terms of clause so-and-so of the tender agreement clause 64 of the General Condition of Contract for adjudicating the dispute which have arisen between the parties. In the petition filed under 11(6) of the Act, the respondent paid for appointment of Sri Ashwini Kumar Kapoor to act as arbitrator. Thus, the respondent itself sought appointment of arbitrator in terms of clause 64. The General Condition of the General Condition of Contract. The appointment of Sri Ashwini Kumar Kapoor as arbitrator, of course, was not agreeable to the appellant, since it was found that Sri Ashwini Kumar Kapoor was not in the panel of arbitrator and therefore would not be considered for appointment as arbitrator. As the value of the work contract was worth more than 164 crore, the dispute can be resolved only by a panel of 3 arbitrators in terms of clause 64(3)(b) of the General Condition of Contract. The respondent was not right in seeking for appointment of a sole arbitrator in terms of clause so-and-so. Considering the various matters of railway contracts and interference with the appointment of independent arbitrator, after referring to Union of India versus MT Gupta and others, judgment in Parmar Construction, the Supreme Court set aside the appointment of an independent arbitrator and directed the general manager of railway to appoint arbitrator in terms of clause 64(3) of the agreement. In para 47 of Parmar Construction Company, the Supreme Court held as under para 47. To conclude, in our considered view, the High Court was not justified in appointing an independent arbitrator without resorting to the procedure for appointment of an arbitrator which has been prescribed under clause 64(3) of the contract under the inbuilt mechanism as agreed by the parties. Applying ratio of Parmar Construction Company and Pradeep Binod Construction Company, the Supreme Court held that the appointment of arbitrator should be in terms of agreement And the High Court was not right in appointing an arbitrator, independent arbitrator, ignoring clause 64 of general condition of contract as held in Parmar Construction Company and Pradeep Vinit Construction Company. The High Court was not justified in appointing an independent arbitrator without resorting to the procedure for appointment of the arbitrator, which has been prescribed under the general condition of contract. Contention: retired railway officers are not eligible. The retired railway officers are not eligible to be appointed as arbitrator under section 12(5), retweet the schedule 7 of the Act, and were statutorily made ineligible to be appointed as an arbitrator. My lord. This point also discussed here, my lord. Height letter dated 27/7/2018, the respondent made a request for appointment of arbitrator. Constitution of Arbitral Tribunal. In response to the same, in response to the same, the appellant sent a letter dated 24/9/2018, nominating the names of 4 serving railway officers, and the respondent was asked to select any 2 names from the list of 4 railway officers and communicate to the appellant. It is seen from the record that the respondent had letter dated 26/9/2018 expressed their disagreement in waiving of the applicability of section 12(5) of the Amendment Act 2015, referring to its own earlier letter dated 24/9/2018 and letter of the respondent dated 26/9/2018, the appellant had sent a communication dated 25/10/2018 nominating a panel of 4 retired railway officers to act as arbitrator and requesting the respondent to select any 2 names from the list in terms of clause 64(3)(b) of the GCC and communicate to appellant within 30 days from the date of the letter for formation of arbitral tribunal. According to the appellant, the respondent failed to select any of the nominee from the panel within the stipulated time of 30 days. The respondent neither responded to the appellant's letter dated so-and-so, nor suggested the names of 2 arbitrators from the panel sent by the appellant. Instead, the respondent approached the High Court under section 11(6) of the Act for appointment of an independent sole arbitrator by filing a petition on 17/12/2018. The contention of the learned counsel for the respondent is that the panel of arbitrator proposed by the appellant by letter dated 25/10/2018, comprising of retired employees of the appellant, are not eligible to be appointed as arbitrator under section 12(5), due to schedule 7 of the Act. Further contention of the learned counsel for the respondent is that the panel of arbitrator drawn by the appellant consists of those persons who were railway employee or ex-railway employee, and therefore they are statutorily made ineligible to be appointed as arbitrator. Contending that the appointment of retired employees as arbitrators cannot be assailed merely because an arbitrator is retired employee of one of the parties. The learned as has placed reliance upon this versus Delhi Metro Rail Corporation. After referring to various judgments and also the scope of amended provision of section 12 of the Amended Act 2015, the entries in schedule 7 schedule, the Supreme Court observed that merely because the panel of arbitrator draws by the respondent Delhi Metro Railway Corporation are the government employee or ex-government employees, that by itself may not be make such person ineligible to act as arbitrator of the respondent DMRC. Here, the Honorable Supreme Court has held that only because he is the retired employee, it does not make him ineligible, by the 12(5) and schedule 7, I will place that judgment also, my lord. It was observed that the person who have worked in the railway under central government or central public works department or public sector undertaking cannot be treated as an employee or consultant or advisor of the respondent DMRC. In para 27 of the Supreme Court held as under. It cannot be said that simply because The person is a retired officer who retired from the government or other statutory corporation or public sector undertaking and had no connection with DMRC. The party in dispute, he would be treated as ineligible to act as an arbitrator. Had this been the intention of the legislature, the 7th schedule would have covered such person as well. Bias or even real likelihood of bias cannot be attributed to such highly qualified and experienced persons simply on the ground that they serve the central government or PSO, even when they had no connection with DMRC. The very person for empaneling these persons is so ensured that the technical aspect of the dispute are suitably resolved by utilizing their expertise when they act as arbitrators. It may also be mentioned herein that the Law Commission had proposed the incorporation of schedule, which was drawn from the red and orange list of IBA guidelines on the conflict of interest in international arbitration with the observation that the same would be treated as guide to determine whether circumstances exist which give rise to such justifiable doubts. Such persons do not get covered by red or orange list of IBA guidelines either. The same view was reiterated in State of Haryana versus GF Toll Road Limited, when the Supreme Court held that appointment of retired employee of a party to the agreement cannot be assailed on the ground that he is a retired former employee of one of the parties to the agreement. Absolutely, there is no bar under Section 12(5) of the Arbitration and Consolidation Amendment Act 2015 for appointment of retired employee to act as an arbitrator. By the letter dated 25/2018, appellant has forwarded a list of four retired railway officers on its panel, thereby giving a wide choice to the respondent to suggest any name to be nominated as arbitrator, out of which one will be nominated as arbitrator representing the respondent contractor as held in so and so. The very reason for empaneling the retired railway officers is to ensure that the technical aspects of the dispute are suitably resolved by utilizing the expertise when they act as arbitrator. Merely because the panel of the arbitrators are the retired employees who have worked in railways, it does not make them ineligible to act as the arbitrator. My lord, it was categorically held, my lord. Merely because they are retired employees, they are not ineligible to act as an arbitrator. Contention: failure to act in terms of the contract is not not responding within 30 days from the date of request. The learned counsel for the respondent has submitted that 5 letter dated so and so. The respondent requested for referring the dispute to arbitrator, but no steps were taken by the appellant within 30 days from the date of the request dated 27/7/2018. It was submitted that on so and so the respondent filed application under Section 11(6) of the Act before the High Court for appointment of sole arbitrator, by which time no steps were taken by the appellant under contract except sending 2 lists of persons by letters dated 24/9/2018 and 25/10/2018 who were de jure ineligible to be appointed as arbitrator. In this regard, reliance was placed upon Punj Lloyd versus Petronet MHB Limited. Considering the applicability of Section 16 of the Act in Punj Lloyd, the Supreme Court held as under. Having heard the learned counsel for the parties, we are satisfied that the appellant deserve to be allowed, appeal deserve to be allowed. The learned counsel for appellant has placed reliance on the law laid down by this court in Dr. Switchgear Limited versus Tata Finance Limited, when this court has held as under. So far as Section 11(6) is concerned, if one party demands the opposite party to appoint an arbitrator, and the opposite party does not make an appointment within 30 days of the demand, the right to appoint does not get automatically forfeited after expiry of 30 days. If the opposite party makes an appointment even after 30 days of the demand, but before first party move the court under Section 11, that would be sufficient. So my lord, in one of the cases, my lord, there is written, my lord, the contention of my learned friend, my lord, for the petitioner, my lord, that my lord, the railway has not responded within 30 days, my lord. But we have shown, my lord, that we have responded within 30 days, my lord. And my second contention is that, my lord, here, my lord, the Honorable Supreme Court has categorically held that, my lord, if, my lord, we do not respond within 30 days, but, my lord, we responded before they approach the Honorable High Court for the appointment of arbitrator, then also that letter will be a valid, my lord, offer, my lord. My lord, I'll come to para 30 now, my lord. The Union of Bharat Battery Manufacturer, my lord. On 33 2000 para 30, my lord, I am reading. On 33 2006, the respondent thereon filed petition under 11.6, seeking appointment of an arbitrator. The appointment of arbitrator, the Union of India, the agreement thereon appoint Dr. Geeta Rawat on 15/5/2006 as sole arbitrator in terms of clause 24 of the agreement. In such facts and circumstances of the case, considering the decision in Poon's Lloyd, the Supreme Court held that once the party files an application under 11.6 of the Act, the other party extinguishes his right to appoint arbitrator. This is, I'll skip this part, but this is these two para is my case, regarding rightly, this two para is relevant for me, because we have either we have appointed the arbitrator within the time, or my second contention is that we have appointed the arbitrator before they approach the Honorable High Court for appointment of arbitrator. So for my cases, these two para is relevant, and I'm relying on these two paras. Now, coming to para 32, contention, general manager himself become ineligible by operation of law to be appointed as arbitrator is not eligible to nominate arbitrator. General manager cannot act as arbitrator, so he is also ineligible to appoint an arbitrator. This point has been discussed, Stand of the Learned Counsel for the respondent is that by virtue of section 12.5, read to its schedule 7 of the Act, general manager himself is made ineligible to be appointed as an arbitrator, and hence he cannot nominate any person to be an arbitrator. The essence of the submission is that which cannot be done directly may not be done indirectly. In support of his contention, the Learned Counsel for the respondent place reliance on TRF. My learned friend also relied on TRF, when the Supreme Court held as under. In such a context, the fulcrum of controversy would be, can an ineligible arbitrator like managing director nominate an arbitrator who may be otherwise eligible and a respectable person? As stated earlier, we are neither concerned with the objectivity nor the individual respectability. We are only concerned with the authority or the power of managing director. By our analysis, we are obliged to arrive at the conclusion that once the arbitrator has become ineligible by operation of law, he cannot nominate another as an arbitrator. The arbitrator becomes ineligible as per prescription contained in section 12.5 of the Act. It is inconceivable in law that person who is statutorily ineligible can nominate a person. Needless to say, once the infrastructure collapsed, this line was my has categorically relied upon, one infrastructure collapse, this superstructure is bound to collapse. One cannot have a building without the plinth, or to put it different, once the identity of the managing director as the sole arbiter is lost, the power to nominate someone else as an arbitrator is obliterated. Therefore, the view expressed by the High Court is not sustainable, and we say so, So, it is an agreement that if the person who himself becomes ineligible to act as an arbitrator, he cannot appoint an arbitrator. But that was argued by my friend also, But here our case, general manager he is not going to act as an arbitrator. The GCC does not provide for that, my lord. General manager only going to appoint an arbitrator, my lord. And my lord, that point has been upheld, that if my lord, general manager only going to appoint an arbitrator, his power is to appoint an arbitrator, he can appoint the arbitrator, my lord. This is, my lord, said mean, my lord, the other paras, my lord. Para 33, my lord. TRF Limited, though the court observed that once the arbitrator has become ineligible by operation of law, he cannot nominate another as an arbitrator. In para 50, the court has discussed about another situation. This is the other situation. Another situation where both parties could nominate respective arbitrator of their choice, and that it would get counterbalanced by equal power with the other party. The para 50 of TRF Limited, the Supreme Court hold as under. We are singularly concerned with the issue whether the managing director, after becoming ineligible by operation of law, is he still eligible to nominate an arbitrator? At the cost of repetition, we may state that when there are two parties, one may nominate an arbitrator and the other may appoint another. That is altogether a different situation, my lord. If there is a clause requiring the parties to nominate their respective arbitrator, their authority to nominate cannot be questioned, my lord. This is our precise point, my lord. What really is that this circumstance can be called in question is the procedural compliance and the eligibility of their arbitrator depending upon the norms provided under the Act and the schedule applied thereto. So, my lord, in our case also, my lord, general manager will not going to act as an arbitrator. He will act, my lord, he will only appoint an arbitrator, and the other party will get an equal opportunity to appoint an arbitrator of his choice, my lord. From the panel, of course, from the panel given by the railway, my lord. Para 34. Considering the decision in TRF Limited, the Perkins Eastman Architects DPC versus HSCC India Limited, the Supreme Court observed that there are two categories of cases. The first, similar to one dealt with in TRF Limited, where the managing director himself is named as an arbitrator, with an additional power to appoint any other person as an arbitrator. In the second category, that is, my lord, our case, my lord, the managing director is not to act an arbitrator himself, but is authorized to appoint any other person of his choice or discretion as an arbitrator. Observing that if the first category, the managing director was found incompetent, similar invalidity will always arise in the second category of case. In para 20 of Perkins Eastman, the Supreme Court held as under. If the first category of case, the managing director was found incompetent, it was because of the interest that he would be said to having in the outcome of the result of the dispute. The element of invalidity would thus be directly relatable to the arise from the interest that he would be having in such outcome of decision. If that be the similar invalidity would always arise and spring even in the second category of cases. If the interest that he had in the outcome of the dispute is taken to be the basis for the possibility of bias, it will always be present irrespective of whether the matters stand under the first or second category of case. We are conscious that if such deduction is drawn from the decision of the court in TRF Limited, all cases having clauses similar to that with which we are presently concerned, a party to the agreement would be disentitled to make any appointment of an arbitrator on its own, and it would always be available to argue that a party or an official or an authority having interest in dispute would be disentitled to make appointment of an arbitrator. After referring to para 50 of the decision in TRF, in Perkins Eastman, the Supreme Court referred to a different situation where both parties have the advantage of nominating an arbitrator of their choice, and observed that the advantage of one party in appointing an arbitrator would get counterbalanced by equal power with the other party. In para 21, it was held as under. The next sentence in the paragraph further show that cases where both parties come parties could nominate respective arbitrators of their choice were found to be incomplete. Is to be completely a different situation. The reason is clear that whatever advantage a party may derive by nominating an arbitrator of its choice would get counterbalanced by equal power with the other party. Para 36. As discussed earlier, after this is our case, my lord. As discussed earlier, after the Arbitration and Consolidation Amendment Act 2015, Railway Board by notification dated 16/11/2016, my lord, has amended the notification notified clause 64. So, my lord, the Supreme Court was concerned, Honorable Supreme Court was very much concerned that this amendment was made after, my lord, the amendment and after the contract agreement was signed. Has amended and notified clause 64 of general condition of contract as per clause 64 3A2, where applicability of section 12(5) of the Act has been waived off in a case not covered by 64 3A1, the arbitral tribunal shall consist of a panel of 3 gazetted railway officers not below the rank of junior administrative grade, or 2 railway gazetted officers not below the rank of junior administrative grade, and the retired officer retired not below the rank of senior administrative grade officer as arbitrator. For the purpose of the the general manager will send a panel of we can skip this because this is regarding appointment of serving railway officers. We'll come to para 37. The clause 64 3B of GCC deals with appointment of an arbitrator where applicability of section 12(5) of the Act has not been waived off. In terms of clause 64 3B of GCC, the arbitral tribunal shall consist of a panel of 3 retired railway officers retired not below the rank of senior administrative retired railway officers, officers retired not below the rank of senior administrative grade officers as arbitrators. For this purpose, the railway will send a panel of at least 4 names of retired railway officers empaneled to work as arbitrator, indicating their retirement date to the contractor within 60 days from the date when a written and valid demand for arbitration is received by the general manager. The contractor will be asked to suggest general manager at least 2 names out of the panel for appointment of contractors nominees within 30 days from the date of dispatch of the request to railways. The general manager shall appoint at least 1 out of them as the contractor's nominee and will simultaneously appoint the remaining arbitrator from the panel or from outside the panel, duly indicating the presiding officer from amongst the 3 arbitrators. The exercise of the appointing the arbitrator tribunal shall be completed within 30 days. 30 days from the receipt of names of contractor nominee. Thus, the right of general manager in formation of arbitral tribunal is counterbalanced by the respondent's power to choose any 2 from out of the 4 names, and the general manager shall appoint at least 1 out of them as the contractor's nominee. In the present matter, after respondent has the present matter has been discussed. So, my lord, through this judgment, the Honorable Supreme Court has discussed this notification, my lord, about 35, 12(5),
7 schedule.
and 7 schedule, my lord. So, my lord, this squarely covers our case, my lord. And my lord, everything has been discussed, my lord. And my lord, one more thing, my lord, I'd like to point out, my lord. Hostile fine, my lord. This judgment, my lord, referred to here, my lord. Well, some paras, my lord, I would like to rely, my lord. It will be good. Well, I'm relying on Monopatra, so my lord, I am giving a copy, my lord, Monopatra, my lord.
Which one you are relying?
My lord, it is, my lord, reported in, my lord, 2017 4 SCC.
Vesto.
Hostile fine. My lord, para 23, my lord.
Pera?
আছে তোমাক কৈ দিছো নেকি right now ওটা আছে নেকি মোৰ কিন্তু অনলাইন আছে পেৰা 23 মাইলত মাইলত ইয়াৰ মাইলত পেৰা 23 মাইলত I may read মাইলত keeping in view the opposite parameters, we avert to the fact of this case, various contingencies mentioned in 7th schedule render a person eligible to act as an arbitrator. Entry number 1 is highlighted by the learned counsel for the petitioner, which provides that where the arbitrator is an employee, consultant, advisor, or has any other past or present business relationship with the party, would not act as an arbitrator. What was argued by the learned senior counsel for the petitioner was that the panel of arbitrators brought by the respondent consists of those persons who are government employees or ex-government employees. However, that by itself may not make such person ineligible, as panel indicates that these are the persons who have worked in the railways under central government or central public work department or public sector undertaking. They cannot be treated as an employee or consultant or advisor of the respondent DMRC. If this contention of the petitioner is accepted, then no person who have earlier worked in any capacity with the central government or other autonomous or public sector undertaking would be eligible to act as an arbitrator. Now, my lord, this is one point my lord already discussed. My lord, we are in the other central organization. My lord, here, my lord, in this judgment, my lord, the modification part, my lord, it was discussed, my lord, in para 27.
In para
27. Before we part, we deemed it necessary to make certain comments on the procedure contained in the arbitration agreement for constitution of arbitral tribunal. Even when there are number of persons empaneled, discretion is with DMRC to pick 5 persons therefrom and forward their names to the other side, which is to select one of these 5 persons as its nominee. Though in this case, it was not done away with. Not only this, the DMRC also nominates its arbitrator from the said list. Above all, the 2 arbitrators have also limited choice of picking up the 3rd arbitrator from the very same list. From the remaining 3 persons, the procedure has the adverse consequence in the first place. This choice given to the opposite party is limited, as it has to choose one out of the 5 names that are forwarded by the other side. There is no free choice to nominate a person out of the entire panel prepared by DMRC. Secondly, with the discretion to the DMRC to choose 5 persons, a room for suspicion is created in the mind of the other side, that the DMRC may pick up its own favorites. Such a situation has to be we are therefore of the opinion that subclause B and C of clause 9.2 of SCC need to be deleted, and instead choice should be given the parties to nominate any person from the entire panel of arbitrators. Likewise, the 2 arbitrators nominated by parties should be given full freedom to choose 3rd arbitrator. So, my lord, here, my lord, this even if you stated that if you direction was given to modify the GCC, my lord, we have modified this GCC, my lord. So it is, my lord, Supreme Court has honorable Supreme Court also, my lord, said that we can modify this GCC to, my lord, accommodate the newly amended clause, my lord. Here, my lord, again it is said, my lord, the second parameter 28. Some comments are also needed to clause 9.2 A of GCC. But this is talking about the GCC, SCC. As per with DMRC prepares the panel of serving and retired engineers of government departments or public sector undertaking. It is not understood as to why the panel has to be limited to a aforesaid category of person. Keeping view the spirit of the amended provision, and in order to install confidence in the mind of the other person, it is imperative that the panel should be broad-based, madam. So, madam, in para 29, it is said, it is therefore become imperative to have much broad-based panel so that discarded any stage of the proceeding, specifically at the stage of constitution of the arbitral tribunal. We therefore direct the DMRC shall prepare a broad-based panel on the aforesaid line within a period of 2 months, my lord. So, my lord, even, my lord, the if choice is given, my lord, they are directed to modify my lord BGCC, my lord. My lord, we have already modified this GCC. So the contents of that we cannot modify this GCC, my lord, to accommodate to accommodate the amendment section. It's not, my lord, not right, my lord, not correct, my lord. The railway has, my lord, has modified the GCC and bring out this notification, my lord, which is, my lord, taken into consideration by the Honorable Supreme Court, and hereafter passed this judgment, my lord. So it cannot be said that this is passed in sub silentio, my lord. This order was passed in sub silentio. It was my lord dealt with, my lord, notification, my lord. And my lord, in this case, my lord, hostile fine, my lord, the direction was given to even modify this GCC, my lord. Even direction was given to modify the GCC, my lord. My lord, here, my lord, we ourselves have modified the GCC, my lord. So how can they say that we cannot modify the GCC after the contract and the modified GCC will not be applicable to contract which was signed earlier, my lord?
Central organization also, the contract was over earlier.
And my lord, in both the cases, my lord, in the central organization, my lord, the contract was is of earlier, my lord, earlier time, my lord. It was signed in 2010, my lord. Amendment came in 2015, my lord. Modification came in 2016, my lord. Notification came in 2016, my lord. And my lord, by this judgment, my lord, it was allowed to, even not allowed, my lord, it was directed to modify this GCC, my lord. Because they have not modified this GCC to make it broad-based, my lord. So, my lord, we have to accommodate, my lord, the amended section, my lord, we have modified this GCC so that, my lord, it does not, my lord, come in the way of, my lord, the appointment of the arbitrator. So, my lord, it has been discussed by this judgment of the Honorable Supreme Court, my lord. And my lord, our case is similar to that case, my lord, and it squarely covers our case.
Nomination of
And my lord, second point, my lord, that GM will not going to act as an arbitrator. He will only nominate the arbitrator, which has been allowed by the Honorable Supreme Court, my lord.
in court.
And my lord, secondly, my lord, this judgment is now before a larger bench, my lord. If there is, my lord, anything, my lord, there is, my lord, the Honorable Supreme Court will, my lord, will look into it, my lord, by the larger bench. But as of now, my lord, this judgment squarely covers our case.
Yes.
So, my lord, this is the ratio laid down by the Honorable Supreme Court, and my lord, this covers, my lord, our AR case, and it is not, my lord, arbitrary.
Yes, Mr. Sharma. you want-
I apologize for not being present when the matter was brought up. Our mixing some of the good. But my learned colleague has already made his submission. I would just like to add one more thing, my lord. If Lordship takes up page 152 of the my lord, arbitration petition, my lord. In arbitration petition number 4 of 2022.
Hmm? Four.
Page 152, my lord, clause 54.
The arbitration petition 4. Page number
152, clause number 55.3, my lord,
page 1.
52. It's clause 55.3. Read out.
Close.
55.3. The contractor shall not be entitled to ask for reference to arbitration before completion of the work assigned to him under this contract. The contractor shall seek reference to arbitration to settle the dispute only once within the ambit of the condition 55.2 above, my lord. Now, all these three petitions, my lord, arise out of the same contract, my lord, and seeking reference, my lord, to arbitration in three different proceedings, my lord. That is not permissible, and recently, my lord, the apex court has, my lord, passed one order, my lord.
What is that? All these three petitions means
Arise out of the same contract. I think.
which three petitions?
1, 2, and 3, my lord.
Huh?
1, 2, and 3. And the petition is praying for three different proceedings, my lord. Arbitral proceedings.
All three petitions in they arise out of the same.
Same contract. And this issue was dealt with by the apex court, my lord. One paragraph order, my lord. It has held that it can be done.
Tantia.
Recent.
There cannot be two arbitration proceedings with respect to same contract.
A learned colleague has already placed the decision in the case of 4, my lord, wherein, my lord, the apex court has, my lord, taken out of section 12.5.7 schedule of the Arbitration Act, my lord, and also the modified GCC, my lord. After taking into consideration all those aspects, my lord, the honorable court has come to a conclusion, my lord, that the railways would be entitled to appoint arbitrators from their list of arbitrators, my lord. The general manager is not the general manager is not depart from nominating the persons, my lord. So in that view of the matter, my lord, the submission that this judgment and in the case of 4 is per inquiry and it passes sub silent, my lord, it doesn't hold ground, my lord. This case squarely covers our case, and, my lord, in view of the fact that a coordinate bench of the apex court, my lord, having dealt with the case and not decided to overrule it and having referred it to a larger bench, my lord, in that view of the matter, my lord, whether, my lord, in my respectful submission, would it be, my lord, would it be proper to, my lord, to hold that judgment to be a per inquiry and judgment that passes sub silent to certain provisions, my lord. That is a otherwise case of 4 squarely covers our case. All the issues were discussed, my lord, dealt with. So our submission is that it's not a judgment that passes sub silent or a per inquiry judgment. That's all.
That's all.
That's all.
Anyway, we'll at 2 p.m. then.
Mentioned in the contract.
We'll continue at 2 p.m. Whatever.
We've already concluded probably, my lord.
Okay.
That's our submission.
Okay.
It's not a per inquiry judgment, my lord. The judgment doesn't pass sub silent to any provision, my lord. And in view of the fact that, my lord, a coordinate bench of the apex court, having considered
the judgment in the case of core Malot, central organization for railway electrification. And having referred it to a larger bench, whether it should be proper Malot in my respectful submission Malot to say that Malot, this is a per inquiry judgment process of Malot. And Malot, so far as the other aspect is concerned, Malot, all these three arbitration petitions arise out of the same contract agreement. So, Malot, in view of clause 55.3, Malot, there can be only one arbitral proceeding with regard to the same contract agreement, and to that extent, that petition, the order of case before. So far as the judgment is concerned, my learned colleague has already placed it before your lordship. It squarely covers our case, my lord. The judgment has taken note of section 12.5, the schedule 7 to the act. Also, my lord, the fact that the memorandum, the GCC, my lord, the modified GCC had come subsequent to the date when the contract agreement was entered into. All these aspects were known to the Honorable Apex Court. So it cannot be said that judgment process sub saliente or that's the per inquiry. And so far as data switchgear is concerned, in that case, the Honorable Apex Court has already held that the authorities are required to modify the arbitration clause so as to bring it in consonance with the amended provisions. And to that extent, the modification is already there. That's all.
Okay, yes.
Much of that.
Lordship, we will be given a date to reply to the arguments. Actually, apparent for 2 and 3 item number. So I apparent for this items. So already learned advocates already stated and which are several judgment is also relied before this honorable court. So already I covered with our issues already, and I am already agreed with this learned friends is also. So and in one agreement, lordship, one agreement is page number 388. So clause number 64.382. So here is also mentioned is the retired rail officer is also there. So as an arbitrator, if any dispute is arises, lordship. So and 3 petitions and 2 petitions is my case, and another is also Vijay Sharma, that is also, and the 3 cases is 2 different lordship. So only the one arbitration petitions is if any dispute arisen in one petitions should have to be this. So and all claims should be clubbed together in one petition. So one actually it is, and that's all is in my humble submission.
Okay, okay.
Lordship, next week, if a date may be given, 23rd.
23rd, huh? Okay. What about you? You want to respond to?
Yes, my lord.
So 23rd, huh? This will be 23rd for Mr. Goswami, K. Goswami, senior counsel to respond, huh? Okay, huh? Senior counsel, Mr. Goswami. Petitioner.
Yes, yes.
Petitioner Goswami.
Yes,
Not respondent Goswami.
Yes, lordship.
Okay. Yes, Mr. Hausa, you
My
want to, yes.
In this case, the notice was issued. First of all, I am coming to my lord, the agreement.
Which one you are referring to? Item number?
8, my lord.
Item number 8.
Sorry, my lord, my senior is there. His item is ahead of my.
Yours is item number, yes, 6.
Lord, this I have argued on last 3 days. Probably lordship is very busy. So many pressures. So
You want to say anything on this?
nothing to add on this because my fact is different from this Bhanumati's case. My fact is reverse, just reverse.
Okay, can you just, yes. Ten of 21, huh? What are the, oh, how do you say that facts are different? Please tell us.
No, in the law, lordship last day asked the same question because
Just a minute, 10. See, in your case, you had submitted the notice on. You submitted notice on.
notice on 21/4/18. Annexure 6, page 92,
21 for
18. 1/8.
notice for what? To settle dispute?
Settle the dispute or else you appoint an arbitrator in page 98.
Page
98.
98.
Plus.
We request you that your contract should be determined under clause 61, decision settle or issue at the earliest. In case, probably we request you appoint arbiter in terms of 64. Now they say that the railway is saying that you have to wait for, you have to wait for passing of 120 days. So 120 days lapse and what?
So railway
But you say that it is 21-4. They say that petition a copy, however, failed to give any decision. According petition, a legal notice on 29,
Yes,
10, 2020.
yes.
Huh?
My lord, it is. Then we have issued another notice on 3518. That is annexure 7, page 109. 109. Page 109.
3518, 30.
5 to 2018.
Is page number?
In page number 109. Then thereafter,
Just a minute. No, after that, please refer to your notice above cited 22-5, sending 2 pages above that advising to send complete. In your view, we have sent complete. We are again sending settlement dispute claim concern. Now, if you start from 35/2018, and 6 months, no, 180 days. Sorry, 120 days is how many?
120 days is 3 months.
3 months, no? So 3 months would lapse, 120 days.
120 days is sorry, 4 months. 4 months.
4 months, no? So formalities would lapse on 39, 2018. Huh? And we have to make the demand then, but within
Demand of
180 days. but
121/4/2018. That is 114, 114 days.
No, when you will count from 21/4/2018 or 35/2018?
No, my lord, I may come.
You know, this, see, as per this clause 61 or something like 63, you have to make a demand. Within 120 days, if they don't respond,
Yeah.
then within 180 days, that means another 60 days, you have to make a demand for arbitration. According to the railways, we have not fulfilled this. That's all one of the plea they have taken.
My lord, what?
So let us see how. So what is your demand? What is your demand? You please tell us. There are 2 dates, 21/4/2018 and 31/5/2018.
We have specifically asked for appointment of arbitration on 21/4/18.
18. Then in that case,
Then it is.
you cannot ask specifically directly.
My lord.
As per the contract agreement, as per the terms of agreement, you have to ask for demand settlement within 120 days. If they don't do it within 180 days, that is thereafter another 60 days, you can demand arbitrator. If they don't, then you come to the court.
My question is that within 114 days, I demanded for arbitration. That is
When did you demand for arbitration?
21/4/2018.
But then did you make a demand earlier? You cannot straight away ask for arbitration.
No, I first demanded that you settle it. This is
So
my
when is the demand made?
demand. That is same on 21/4. I have
No,
demanded.
you cannot make this demand settlement the same on the same day and also appoint arbitrator. You cannot make that. That is what the term says. Your agreement, what is your agreement? Case
Agreement is space.
settlement. Page 88, demand for arbitration.
My lord.
Page 88, please come to page 88, 64-1-1. Is the one you are referring? 61? 64-1
My lord.
In the event of any dispute difference between the parties here to as your construction so dispute difference withhold tourism entitled if railway fails to make a decision within 120 days, then in any such case, but except in any accepted matter, the contractor after 120 days but within 180 days is presenting his final claim shall demand writing that the dispute be referred to arbitration. Is it the one you are relying on?
Yes.
Now, So for 120 days, you have made the demand for final settlement and the arbitration on the same day.
Same.
How can you do that? Is it in consonance with clause 64?
64, what 64 says is that, my lord, demand for arbitration, 64(1)(1).
Demand for arbitration. When can you make a demand? First, you make a claim.
Click.
Wait for 120 days.
Make-
The railways do not respond. Then you make a demand for arbitration after 120 days, but within 180 days. That means another within 60 days, you have to make a demand. If you don't do it, then it cannot be, there cannot be arbitration. That is what they are saying. So what do you say about it?
No, my question is that I have repeatedly demanded
Or you
since
repeated,
1804. And then again, they have said that you give us details of something. They responded to my letter.
so you can again send on 35/2018.
Email,
Huh?
exactly.
Then 31/1/2018, you have made a demand also to settle. So you have to wait till 120 days, and 120 days will lapse on 39 September 2018. Then you have to make a demand within another 60 days. That means 2 months. So 39, 10, 11 November 2018. You have to make the demand.
My lord, I was waiting, and they have not responded to it ultimately. So what should I do then?
What is it?
Because, my lord, I am a businessman. I have to wait till in some response. We are expecting some response from the railway. And ultimately, we send a notice. We are compelled to send a notice.
And when did you approach this court?
On, my lord,
You filed under section 11
11,
on when?
it is in the 5th of April 2021.
2021.
21.
But you are late. They are. So when the cause of action arose?
Cause of action arose last was 35 2020.
What is the limitation period? When the limitation period will start running and it'll,
No,
is there any delay?
no.
Because they are saying there is a delay.
What delay?
So you have to tell us that there is no delay.
There is no delay. There is no specific limitation under the Arbitration Act. It is, we will have to go by the Limitation Act. 3 years. No specific was stated in the Arbitration Act about filing an application under 11(6). We are compelled because they have not appointed, neither they responded to it nor or so far as, my lord, this 2020 14 SCC is concerned, my fact is completely different. It is just reverse. It is in para 31 is to be noted.
So tell us, please, please. See, Mr. Swami, you are appearing in this case.
But actually, I'm not appearing this way in this matter.
Who is appearing?
More,
More,
yes, more.
what is more?
Well, actually, he rang me up in no, actually, from railway, I was informed that he's not well today.
Huh?
He's not well today. That's
Not
why
well
he's not
today. Because I want to know whether this, because see, whether the railway authorities made any proposal that will appoint. No. They have not responded till now. Till the filing of this application under section 11, they have not responded. Only now they are offering.
In that case, my lord. But
Then you
I
have
am-
forfeited the right, whatever you want to.
But since I am not there, well, I do not have the final, so I do not know. my lord.
Okay. Okay. Then what to do? Is a more or more? More or more? JP more or JP more?
More.
More.
On 23rd, my lord.
Huh?
On 23rd, my lord.
23rd, okay.
This may be also taken up on 23rd.
Okay, then your case is that you have, okay, then they have not responded, therefore you have come. Okay.
My lord, may I be relieved because I have to go to Hyderabad to pick my wife up on medical.
Okay, but we have some junior to assist, he can just.
He will be here.
No. Yes, sir, now Mr. Hussain, perhaps R. Hussain.
My lord, in this case, I am coming to the agreement, my lord. At page number 19, my lord.
Arbitration petition number?
Petition number, my lord, 29.
29. This is number 8.
Yes.
What about number 5, 9? No.
Number 5 has been adjourned, my lord.
Adjourned. Okay. So this is 29 of 21. Durga Krishna store.
Yes.
Item 7 is there, my lord.
Huh? Item number 7. Oh, 7 also there. Gamam, BR. But then this Durga Krishna is there railways involved? No.
Railway.
Yes, but I'm a.
Railways. But in Gamam? Huh? No, but there is BRO. We are doing with this the railways, that is why. Huh? So here Durga Krishna store versus Union of India. In this case, what is the Durga Krishna? Durga Krishna, I think.
And my lord, they have referred some notification. I want to have a look on that also.
What notification?
About the amendment of the GCC, my.
That then 19.
Copy is not with me, my lord.
Oh.
I asked.
Yes. I got a copy I can give, but you have to return to me. We can share. You know, what are the facts of the case? In your case, facts.
My lord, in this case, my lord, I issued the notice and
You are also engaged in supplying what? Supply of
for
what?
construction, my lord.
Huh?
for
You're for construction. You are a
For
store
construction
private
of-
limited.
Station building, my lord.
Huh?
Station building and platform.
You are a
At-
Durga Krishna store.
Yes, my lord.
You are a owner of a store or you are building also, huh?
Construction company.
Construction company.
My lord, construction of station building, RBG room, passenger platform, shelter, staff quarter, station approach and other ancillary work at Dhola station in connection with construction of BG railway line for Jiribam to Imphal. And
Jivam
to Imphal,
Imphal.
page
So-
19, my lord.
So you are also one of the responsible for delay of this.
No, my lord,
No.
so many situations are there.
Huh?
This,
We thought the Imphal line will be completed. They are not doing it. Delay.
now, Imphal line will be completed soon, my lord.
Soon.
There was some court cases were going on, but that were solved, my lord.
Solved.
Yes, that was
I
solved.
see. Very good.
There are interim order, so my lord, they could not proceed actually,
Huh.
that interim order, but that was vacated.
Okay.
Now, my lord, probably it will be completed very soon.
Okay, very good. So, but he also was involved in this, huh?
Yes,
Huh?
part of the work we completed.
Completed.
Yes,
So then after that, you complete then as per receipt resources.
My lord,
Then
yes.
what happened?
my lord,
Then-
I am. Then my
Then your contract was terminated.
terminated
By whom?
by the railway.
Okay. Contract terminated by railways. When?
On 19 to 2018,
19 to 2018.
18.
19 to or 19-1?
19 to my,
19 to
yes,
2001.
2018, my lord.
Sorry, 19 to 2018, it was terminated. Then after that, what did you
Then,
do?
my lord, I lodged my final claim
When did you lose?
on 30/3/05, 2018.
30,
5, 2018, 30th May.
lose the final claim.
Yes.
And then what happened?
Then, my lord, I invoked the arbitration clause on 22/11/2018.
22/11
2018.
invoked arbitration clause. Now, is it 120 days? Is within 120 days?
Yes. This issue is not, this is within 120 days.
So 35 to 11, this means when the 120 days elapsed?
4 months, after 4 months.
No, 5.
I filed on
You lost the final claim on 35.
35.
So 120 days you have to wait, no?
Yes.
So
4 months.
120 days will be 4 months, huh?
4 months.
4 months will be 9, huh?
Yes.
So 30 will be 39, 2018. And within 2 months you have to claim, make
Yes.
the arbitration. So that is within, huh?
Yes.
So therefore within 120 and 180 days
Yes.
requirement. So there is no issue on that.
Yes.
Then what happened?
Then,
You
my lord,
invoke-
instead of appointing the arbitrator, they made a reply and requesting me to waive the condition of 12/5, my lord.
Okay.
On
So railways
17 to 2019.
on 17,
To 2019.
railway asked for waiver.
Waiver.
Then what did you say?
Then, my lord, I declined
When?
to waive my on 20th March 2019.
2019. Petitioner declined the waiver.
Then I filed the petition, my lord, in this honorable court.
When did you file?
My lord. On 24/8/2021. After lockdown.
And in the meantime, they have not appointed any arbitrator.
No, my lord.
So they have waived their, according to you, they have
Yes.
waived their.
Actually, not waive, my lord. We
Is-
asked them to, my lord, waive the my lord.
And he declined. Then he declined.
He declined, my lord, and my lord, what the letter.
After that, after
After
that,
that, my lord, after that, my lord, what happened? The letter is, my lord, on page, my lord, I'll show you the letter. At page 108, my lord. At 108, my lord.
yes.
Annexer 15. Dear sir, under the instruction of my client Durga Krishna Store Private Limited, House number so and so, Kasar Assam, with reference to letter dated 17/2/2019, my client had declined to accept your offer for amendment of arbitration agreement. Amendment of arbitration agreement. My client is also not bound to accept such offer, which against the term of agreement and law. So the Railway Board guidelines dated 16/11/2016 is also not applicable in the instant case, as both parties signed the agreement way back in 1991.
So you say you're not binding on me. I don't know.
Not binding. So,
Then?
we made the offer, madam.
Huh?
We made the offer.
You made the offer, but then
Neither we can engage, neither he will.
no, but then in that case, note waive, huh?
Not waive.
You note waive, then you could have invoked a note waive clause.
Not waive.
Close.
Yes, my lord.
At least you could have proceeded to appoint whatever it is, but you not do that.
But my lord, what he has said, my client has declined to accept your offer.
Doesn't matter, he has
What-
declined your offer.
Amendment of
So
arbitration.
if he doesn't want to amend, because amendment will be required express, no? So he doesn't want,
My lord.
then the option, what is the option? Then you proceed according to what you think is correct. That is non-waiver. If it is a non-waiver, then you will invoke whatever 64(3)(b) or whatever is there.
Yes, my lord.
You will say retired, go for retired.
Retirement.
You didn't do that
But,
also.
since my lord, he said that we.
I say, I don't know interested.
I
I
am
am-
not interested, and he.
Then okay, then you could have said, okay, doesn't matter, if you are not interested, we invoke this clause. So we'll offer you, these are the, so you make an appointment, choose one of our retired persons. That you didn't do.
My lord, probably that.
Just note down these facts so that, and Mr. Hussain Rane, counsel for the House, Goswami for this. And in the present petition has been filed seeking for appointment arbitrator under section 11 of Arbitration Consolidation Act. Brief of the case leading to the filing of this application is that the petitioner was awarded certain contractual works by the railway authorities for construction of station building, RBG rooms, passenger platform, PP shelter, staff quarters, station approach and other ancillary works at Dholakhal station in connection with the construction of new BG road, BG railway line from Jiriwam Imphal. White contract agreement number CON/J-1/1519 dated 19/1/2012. As per the said agreement, the work was to be completed on or before 21/2012. Huh?
Yes, ma'am.
Date of completion was fixed on or before 21.
Yeah.
How can it be 19/1?
Well, so
In
many
what?
extensions were granted.
Huh?
So many extensions. were granted.
And which was extended from time to time. However, because of various, according to petitioner, because of the worsening law and order situation in the state of Manipur, he could not execute the work properly, taking advantage of the said position, the railway authorities terminated the contract on 19/2018. Full stop. Thereafter, the petitioner submitted his final claim, lodged the final claim before railway authorities on 30/5/2018.
Yes.
13/12/18. In spite of such final claim being made to the railway authorities, the authorities did not settle the same. And in view of the above, the petitioner via letter dated 22/11/2018 invoked the arbitration clause for appointment arbitrator to settle a dispute between the petitioner and the railway authorities. Full stop. In next para, petitioner submits that after the petitioner invoked the said arbitration clause as per the agreement, contract agreement, the railway issued a letter on 17/2/2019 asking for waiver of the waiver of what clause? Waiver of the
Clause number 12(5).
12(5).
Section 12(5).
Waiver in terms of clause 12(5).
Section 12.
And under as contemplated under section 12(5), 12 within bracket 5 of the Arbitration Consolidation Act, which would have enabled the railway authorities to appoint arbitrator from enable of their choice of employee of ex-employee. Full stop. However, the petitioner declined to decline the waiver sought for by the railway authorities by letter dated 28/3/2019. Full stop. The case of the petition is that even though the petitioner had declined to waive the conditions as contemplated under section 12 within bracket 5 of the Arbitration Consolidation Act, the railways authorities do not proceed to make any to appoint an arbitrator, compelling him to file this approach this court by filing this application petition on 24/8/2021 for appointment arbitrator under section 11 of the. Yes.
That notification, my lord, which passed by the railway board, my lord.
Yes.
Notification, that was sent.
That was?
That was sent to me.
That was sent to him.
Sent to him. My lord, he has an X, my lord, page 106, my lord. So, my lord, both the options are given.
Next one.
Both the options.
As far the aforesaid factual submission narration by the petitioner is concerned, it has been submitted by Mr. G. Goswami, Learned Standing Counsel for the.
My lord, may kindly see 106 page, my lord.
Huh?
Page 106, my lord.
106. Submits that the petitioner was specifically furnished with a copy of the notification issued by the railway authorities
11,
on 16/11/2016, which was brought into what existence after the amendments to the Arbitration Consolidation Act was made in 2015. 15. Thus, the petitioner was fully aware of the changes brought in by the railway authorities
And my lord, he has
in
replied,
line
my lord.
with the section 12(5) of the Arbitration Conciliation Act.
And my lord, he has replied, my lord, at 109, my lord.
Yes. However, the petitioner chose not to. Petitioner chose to ignore the said.
No, not ignored. He said, my lord, railway, but guidelines at 16/11/2016.
However, the petitioner took the plea that the said notification is
It is
applicable
not applicable.
to the petitioner.
So, my lord, there is no point of my lord giving him, my lord. He has declined to, my lord, accept that notification.
You innocent, but then it doesn't mean that he may say whatever he wants, but you should have done your job also.
My lord, since, my lord, he has declined to accept that notification. my lord,
According to the SME submitted, since the petitioner had declined to accept the said notification dated 16/11/2018,
Footless
the railways did not make any further steps, as it was futile to respond to the plea of the petitioner for appointment of arbitrator, divorce the rules and divorce the terms of contract which have been modified by the authorities, of which he was fully aware of. That's all. And as such, but then now what is to be done?
My lord, we may be, my lord, I have categorically stated in my affidavit opposition that we may be allowed to engage.
Under the circumstances, it has been submitted that if the petitioner is willing to settle the dispute through arbitration, the railway authorities are willing to constitute the arbitral tribunal in terms of the aforesaid notification dated 16/11.
Yes.
11/11/2000.
16/11/2016.
On the other hand, Mr. R. Hussain submits that stage is far already over, in as much as they ought to have taken whatever necessary step they thought permissible under the rules and the terms of contract before the petitioner approached the court. Once the petitioner has approached this court invoking section 11 of the Arbitration Conciliation Act, it will be deemed that the railway authorities have waived their own right to appoint arbitrator in terms of their own notification and the terms of the contract. And it is only the court now which can appoint the arbitrator. That's all. That's your case. That's all. Anything else you want?
Now, in this respect, my lord, I am coming to that about their notification. They are saying notification, but the railway is saying it is a guideline.
Guideline, it is a guideline.
Yes. Page 105. A guideline is not a law, not a contract. 105, my lord.
Legal appointment, reference to guideline board.
Railway guideline.
Mr. R. Hussain, Lana Council for the further submits that even though the railway authorities are heavily relying on the aforesaid notification dated 11/11 or 16/11?
16/11.
16/11/2000.
16.
It is merely a guideline, is merely a guideline which is not binding on the parties. In fact,
Rather, it is binding on the railway officers.
and it is only binding, it may be binding on the railway officers,
Yeah.
but not to
Contractor.
to the contractor,
Which is bound by the contract agreement.
which is bound by the contract agreement only. In fact, the fact that it was considered, it was stated to be a guideline is clearly mentioned in their letter dated 17/2/2019 issued to the petitioner.
Now, in this respect, my lord, first case I will refer.
And
Yeah.
my lord, my submission is, my lord, that my lord, we are under confusion, my lord. And only after my lord, this judgment of the Honorable Supreme Court comes, my lord, my lord, then only my lord, my
Okay.
lord becomes.
Mr. Swami, Learned Counsel was, however, submits that even if there be any doubt about the legal status of the said notification dated 16/11/2016, the matter is now settled beyond any pale of doubt by the Honorable Supreme Court in Central Organization so-and-so, where it has been held that the said guideline is applicable for appointment of arbitrator by the railway authorities.
And my submission is that, my lord, that case is not applicable because the facts of that case is different from the facts of my case.
Next, Mr. R. Hussain, our submits that the said case in Central Organization is not applicable to the present case in much as the fact situation are very different in the present case, and as such, the decision of that case will apply only in the particular facts obtaining in that case, not in the present case.
Yeah. Now, first of all, my lord, I am coming to my agreement, my lord. Page number 19, my lord.
Yes.
Whereas the contractor has agreed with the railway of the performance of the work for construction of station building, RBG rooms, passenger platform, PP shelters, staff quarter, station approach road, and other ancillary work at Dholak Hall station in connection with construction of new BG railway line from Jiribam to Imphal, set forth in the schedule here to annex upon the general conditions of contract of and the specification of the Northeast Frontier Railway 1998 edition. Now we cannot go beyond that, my lord. So many amendments were made, my lord. So many GCC editions are available. As per my knowledge, my lord, 2011 is there, 2010 is there, 2013 is there, 2014 is there. Now 2020 is also available, my lord, and or are also available on the online, my lord. And before that, my lord, your lordship may kindly come to there. My learned brother has annexed some copy of the some GCC. But which edition of GCC, it is not clear because first two pages are not available. Page number 19, annexure 2. The arbitration clause.
Page number
19 of their counter affidavit.
19.
Because the answer lies in the first two pages, which is not available. Annexure 2, page 19. This relevant portion is there, but first 2-3 pages are not there. And the answer lies there. Why the answer lies there, I am coming to that, my lord. And this judgment will clarify. Both the answer will be given by this judgment. My lord, this is recent judgment, and I am coming to my lord, page number, paragraph 3.1, my lord. It is submitted that the parties to the agreement are governed by the arbitration agreement clause in terms of the clause 32 of the agreement. It is submitted that despite invocation of the arbitration clause in terms of the agreement, the respondents failed to appoint an arbitrator.
It is contended that therefore the respondent forfeited its right to appoint an arbitrator under the agreement, and therefore the High Court was required to appoint a sole arbitrator in exercise of powers under section 11(6) of the Act. Reliance is placed on the decision of this court in the Deep Trading Company versus Indian Oil Corporation. It is further submitted by Sri Ramesh Singh, London senior advocate appearing on behalf of the appellant, original applicant, that the High Court has seriously erred in directing the parties to appoint arbitrator in terms of the clause 64(3)(b) of the GCC. This is also railway case, my lord. It is contended that in the present case, the general conditions of contract is not applicable as at all on the grounds inter alia that neither the GCC has been signed by the parties nor the governing agreement makes in any reference to the GCC. Here also GCC is not signed, my lord. The parties to the original agreement are neither signatory to the GCC, nor the GCC is made part of the original agreement entered into between the parties. Even as per the communication dated 16/7/2020, the GCC July 2020 shall be applicable towards contract on Indian Railway with prospective effect. It is submitted that therefore the High Court has seriously erred in directing the constitute an arbitral tribunal as per the clause 64(3)(b) of the GCC. Shri K.M. Nataraj, learned ASG, appearing on behalf of the respondent, is not in a position to dispute that after the invocation of the arbitration clause, the General Manager Railway failed to appoint the sole arbitrator in terms of the agreement. He is also not in a position to satisfy the court as to how the general conditions of contract shall be applicable with respect of the agreement between the parties, which has been entered into much prior to the GCC coming into force, that is July 2020, and that neither is there any reference to the GCC in the original agreement, nor the GCC has been signed by the party. Therefore, he is unable to support the impugned judgment and order passed by the High Court directing to constitute an arbitral tribunal as per clause 64(3)(b) of the GCC. We have heard the learned counsel appearing on behalf of the respective parties at length. It is not in dispute that the parties to the agreement agreed to resolve the dispute as per clause 32 of the original agreement, which reads as under. Clause 32 arbitration. In the event of any question, dispute or difference arising under or in connection with the agreement, except as to matters the decision of which is especially provided for by this agreement, the same shall be referred to the sole arbitration of a person appointed to be the arbitrator by the general manager or the railway. It will be no objection if the arbitrator is a government servant that he had to deal with the matters to which the agreement relates to, or that in the course of his duties as a government servant, he has expressed views on all or any of the matters in dispute or difference. The award of the arbitrator shall be final and binding on the parties to this agreement, provided always that the decision of the general manager of the railway as to the dispute which fell within the accepted matters referred to the above shall be final and binding on the parties hereto, and such decision of the general manager shall not be called in question before the arbitrator by either of the parties hereto. In the event of arbitrator dying, neglecting, or refusing to act, or resigning, or being unable to act for any reason, or his award being set aside by the court for any reason, it shall be lawful for the authority appointing the arbitrator to appoint another arbitrator in the place of the outgoing arbitrator in the manner aforesaid. It is further a term of this agreement that no person other than the person appointed by the authority as aforesaid should act as arbitrator, and that if for any reason that is not possible, the matter is not be referable to arbitration at all. The appellant and the respondent, being signatory to the agreement, are bound by the aforesaid arbitration agreement. As the dispute arose between the parties, the appellant invoked the arbitration clause in terms of the agreement. However, the respondent, general manager, railway, failed to appoint the arbitrator in terms of the clause 32, reproduced herein above. That thereafter the appellant herein approached the High Court for appointment of sole arbitrator in exercise of power under section 11(6) of the Act. Once the dispute has arisen between the parties, and despite invocation of the arbitration clause in terms of the agreement, no arbitrator is appointed, it can be said that the authority has forfeited its rights to appoint the arbitrator in terms of the arbitration agreement. And thereafter the arbitrator has to be appointed under section 11 of the 6 of the Act. At this stage, the decision of this court
in the case of deep trading company is required to be referred to. In the said decision, it is observed and held that once an arbitrator is not appointed as per the agreed procedure within the stipulated time, right of the party concerned to appoint an arbitrator is forfeited. And therefore, the Chief Justice ought to have appointed an arbitrator under section 11(6) of the Act. In the said decision, the corporation therein appointed the arbitrator as per the agreed procedure during the pendency of the proceeding under section 11(6) of the Act. And to that it is observed and held that appointment of the arbitrator by the corporation during pendency of the proceeding under section 11(6) of the Act was of no consequences. As failing to appoint an arbitrator within the prescribed time, the corporation has lost its right to appoint an arbitrator. In the present case also, the respondents failed to appoint an arbitrator as per the agreed procedure and in terms of the agreement. Therefore, the respondent forfeited its right to appoint an arbitrator in terms of the agreement. And therefore, the appellant was justified in filing the application before the High Court for appointment of sole arbitrator in exercise of power under section 11(6) of the Act. The Chief Justice or his nominee thus was required to appoint the arbitrator under section 11(6) of the Act. By the impugned judgment and order, and while allowing the application under section 11(6) of the Act, instead of appointing the arbitrator in exercise of power under section 11(6) of the Act, the High Court has directed to constitute an arbitral tribunal in terms of clause 64(3)(b) of the GCC. It is not in dispute that neither the GCC was signed by the parties nor the GCC was made part of the agreement between the parties. There is no reference to the GCC in the main agreement entered into between the parties. Even as the communication dated 16/7/2020, the GCC July 2020 shall be applicable to works contracts of Indian Railway with prospective effect. The GCC itself says, my lord. Therefore, that is why the 2 pages will reflect the nature of the GCC, my lord. Therefore, the parties are not governed by GCC at all. Therefore, the High Court has committed a serious error in directing to constitute an arbitral tribunal in terms of the provisions of the GCC which are not binding to the parties. In view of the above and for reasons stated above, the impugned judgment and order passed by the High Court to the extent directing to constitute an arbitral tribunal in terms of clause 64(3)(b) of the GCC unsustainable and deserve to be quashed and set aside, and is accordingly quashed and set aside. The Chief Justice or his nominee was required to appoint an sole arbitrator in exercise of power under section 11(6) of the Act. The High Court has failed to appoint the sole arbitrator in exercise of power under section 11 of the Act. Therefore, as such, the matter is required to be remanded to High Court for appointment of a sole arbitrator. However, instead of remanding the matter to the High Court and to avoid any further delay, with the consent of the learned counsel appearing on behalf of the respective parties, we appoint Srimati Justice R. Bhanumati, former judge of this court, as a sole arbitrator to adjudicate and resolve the dispute between the parties. So this case is fully covering facts of my case, my lord. And regarding, my lord, this central organization case, my lord, this talks about some amendment, my lord. And unilaterally amendment of the contract is not permissible. Or circular or guidelines is not applicable in the contract, my lord.
In this circular guideline, is it mentioned that it is prospective in nature? In that circular?
Circular, my lord.
Have you seen a copy of that?
This, yes.
16.
Yes, yes.
What does it say? Amendment.
Subsequent to the promulgation of the Arbitration and Conciliation Amendment Act 2015, clause 64 of the General Condition of Contract GCC 2014. Here GCC 2014, my lord, has been modified while Railway Board's letter referred above. However, during issue of the letter, the draft copy of the annexure regarding format of certification by the arbitrator was inadvertently included. It says about amendment of GCC 2014. In our case, GCC 1998 is applicable. In between, so many GCCs were
In
also
your
there.
case, is this NFR 1998?
Yes, 1998.
Here to upon GCC and the specification of the annual edition corrected update. And this is GCC 2014.
So how it will be applicable, my lord? From
Yours is 2012
yes,
agreement.
yes. Even my contract was terminated in 2000, my lord. 2018. Yes. And it is, contract was entered into 2012. How it will be applicable?
In view of the promotion, it has been decided by board to modify clause 60 for Indian Limited as under modification of clause and Innovation Act as per list.
This is not a law, my lord. GCC is not a law. This is a part of the contract, my lord. Unilateral amendment, your lordship knows, unilateral amendment of the contract is not permissible. And in this respect, my lord, I am referring this section 62, my lord, of the Indian Contract Act, my lord.
Mr. Hussain, R. Hussain, Land Council for the opinion submits that perusal of the recital of the contract, copy of which is annexed as annexure 2 to the petition would show that this agreement has been entered between the contractor and the railway authorities in terms of general conditions of contract and the specifications of the Northeast Frontier Railway 1998 edition, corrected update, and special conditions and special specific, if any, in conformity with drawings there herein into annexed and which and since and a said contract agreement was executed on 9/1/2012. Therefore, any subsequent amendment to the GCC will not be applicable, be not being part of the contract agreement, will not be binding on the petitioner. Further, referring to the amended GCC, which have been relied on by the railway authorities, copy of which is annexed 2, it has been submitted that it is not clear from the said annexure as to when the said amendment were brought into effect, and in absence of any such clarity, any subsequent amendment will not be binding on the petitioner. First off, in this regard, Mr. Hussain also relied on a decision rendered by the Honorable Supreme Court in MS Continental Private India Private Limited versus General Manager Northern Railway, within bracket civil appeal number 4829 of 2022, decided on 27/7/2022, in which it has been clearly mentioned that terms of any amended terms of the GCC, which were not part of the original contract agreed between the parties and signed by the parties, will not be applicable, and the appointment arbitrator has to be determined on the basis of the agreed terms and condition signed by the parties, executed by the parties.
And
Yes,
yes, my lord. Further, I would like to submit, my lord. No, GCC is mentioned 1998 in this agreement, my lord, but GCC 1998 arbitration clause is incorporated in the agreement. So this is a special clause which is incorporated in the agreement, and GCC is a general clause. So when the special clause is there, normal, as your lordship knows, normal practice of the interpretation is that a special clause will exclude the normal general condition, my lord, at page 61, my lord. So reference of GCC is not relevant here when it is incorporated in the agreement itself, my lord. It is signed by the page 61, my lord.
Page 61 of your?
Of my petition, my lord. Here, my lord, the arbitration clause incorporated in the agreement.
It has been further submitted that the arbitration clause have been specifically incorporated in under para in clause 16.
15, my lord. Yes, 16, my lord.
16, 16. And the general conditions of contract, clause 64 of general conditions of contract, which have been relied upon by the railway authorities, cannot be applicable in a it does not form part of the contract, a specific contract entered by between the parties on 19/1/2012. And as such, and as such appointment by arbitrator or settlement dispute has to be in terms of the agreed terms and condition incorporating the agreement executed on 19/1/2012 as provided under clause 16 of the said agreement.
Now,
Yes.
yes, my lord. Further, my lord, the Honorable Supreme Court says unilateral amendment in the contract by a party is treated to be a fundamental breach of contract committed by the party.
Next, Mr. R. Hussain further submits that any unilateral change in the or change or amendment in the terms of contract would amount to
Fundamental breach of contract.
fundamental breach of contract. And as such, even if regular authorities are seeking to change the terms of the agreement by relying on the modified GCC as notified on 16/11/2016, the same cannot be applicable to the present case as it would amount to a change in the terms of the contract, which is impermissible as held by the Honorable Supreme Court in Sangyong Engineering and Construction Company Limited versus National Highway Authority of India, 2019, volume 15, SCC 131. Para number?
Paragraph 76 and 77, my lord.
Para?
76 and 77. Last page, my lord. This relevant portion is here. However, when it comes to the public policy of India argument based upon most basic notions of justice, it is clear that this ground can be attracted only in very exceptional circumstances when the conscience of the court is shocked by the infraction of fundamental notions or principles of justice. It can be seen that the formula that was applied by the agreement continued to be applied till February 2013. In short, it is not correct to say that the formula under the agreement could not be applied in view of the ministry change in the base indices from 1993 to 1994 or 2004 to 2005. Further, in order to apply a linking factor, a circular unilaterally issued by one party cannot possibly bind the other party. So this is guideline, circular, notification, same thing. To the agreement without that the other party's consent. That is why they wanted consent, my lord. Indeed, the circular itself expressly stipulates that it cannot apply unless the contractors furnish an undertaking affidavit that the price adjustment under the circular is acceptable to them. We have seen how the appellant gave such undertaking only conditionally and without prejudice to its argument that the circular does not and cannot apply. This being the case, it is clear that the majority award has created a new contract for the parties by applying the said unilateral circular and by substituting a workable formula under the agreement by another formula. Dehors the agreement. This being a case, a fundamental principle of justice has been breached, namely that a unilateral addition or alteration of the contract can never foisted upon an unwilling party, nor can a party to the agreement be liable to perform a bargain not entered into with the other party. Clearly, such a course of conduct would be contrary to the fundamental principle of justice as followed in this country and shock the conscience of this court. So this is not permissible, my lord. However, we repeat that this ground is available only in very exceptional circumstances and such as the situation in the present case. Under no circumstances can any interference with this is regarding to the award money. So unilaterally change, so many other judgments are there, my lord. So here, my lord, once they have forfeited their right, they have no right to say anything, my lord, about the applicability of their agreement, my lord, in view of the law done by the Honorable Supreme Court, my lord. And here, this is a fit case, your lordship may appoint the arbitrator from the High Court panel. Now the High Court panel is available, my lord.
Okay. Yes, Mr. Goswami.
My lord, this news has been, my lord, MS Continental India Private Limited. My lord, this is new to me, my lord. I'll go through this, my lord.
You can go through
Number
25th.
Then the other, my lord, Sanyong
Yeah.
Energy, my lord.
Yes.
Well, if I heard my lord correctly, I heard correctly, my lord, there is some circumstances, my lord, where my lord, the change is applicable, my lord. In our case, my lord, it is to my lord, this amended provision, my lord. To bring the amended provision, my lord, this amendment was made by you. Only to be.
Okay.
And my lord, I would like to cite some judgments on what is the legal value of the guidelines, my lord.
Yes.
On next date, I will.
Next day.
Yes.
Okay.
Along with this.
I'll also
special-
reply, my lord.
Okay.
And because the other part, my learner brother, Mr. K. Goswami has already submitted. So that also I am adopting. And apart from that, in my case, I have already made some.
After everybody has finished their submission, maybe everybody may be requested to sum up. So that because this matter is being heard in installments, you know. So, I mean, just not that I remember most of the things so that there is continuity because it will help me in passing the judgment faster. Otherwise, I have to sit down, meditate, try to recollect, look upon the star in the night, trying to, then yes, slowly the memory will come back. So instead of that, I would request, I have more or less noted down everything. There is no issue on that. I am not saying you are not required to re-argue. Just point this is, that's all. And if some written, perhaps Mr. K. Goswami has given a written submission also. If you can give just briefly one page, just a point that will help recollecting. So we'll continue on then 23rd. 23rd.
Much.
Item number 7.
Yes. Yes. What is this Gamam engineering? And who is the other side? Border roads. You're there. Yes.
Now, so the issue raised in this petition by the opposite party is that the petition under section 11 is barred by limitation laws.
Okay.
That we concede to the point because it is actually barred by limitation. We have
Then what to do? If it is barred by limitation, clearly what the Supreme Court says they should be finished. Why should you? Yes.
Only prayer from our side is that we may be given the benefit of section 14 of the Limitation Act. So we can go because the claim is not time barred.
Okay.
So only that observation will do. Otherwise, we have no case to appoint an arbitrator. We have no case to appoint an arbitrator because it's barred by limitation.
Yes.
It is on face of the record. So only thing that if our claim is not time barred. So if we go for in a suit, the benefit of section 14 should be given.
It can't be, my lord, because section 14, my lord, to invoke section 14, first of all, my lord, to
see, here I approach this code under section 11. He admits that this is barred by limitation. For as far as the arbitration concerned, we are not going to pass an order. He was just one observation that he can apply. He is up to the authority. He can make an observation. We are not giving him any by this. We are not directing. We are not giving any lease of life. We are saying that he says that he can apply. He can try to convince the alternative forum if it is permissible in law.
It is not permissible. First of all, my lord have to see, my lord, whether under section 14, my lord can exercise the jurisdiction, my lord.
Limitation Act.
This court has no jurisdiction, my lord, to enter in this petition, my lord. Then, my lord, section 14 will come, my lord, of Limitation Act, my lord.
No, section
14 of Limitation Act.
Right. No, it is for him to, we'll see that it is for him to do that. We are not asking that, yes, you can invoke section 14. We said that he wants to invoke whatever is up to him. We cannot deny whatever he wants to do. That we cannot. If he wants to invoke section 14,
yes,
let him do so before the appropriate forum. This is not the forum.
My lord, so first, my lord, give him an observation that this court has no jurisdiction to enter in this 11-6 petition.
You will not, yes, that
because, my lord, the last word, my lord, that there has to be some defect, my lord.
Yes.
To enter in such 11-6 petition or not, my lord. He has to show, my lord, this court has no jurisdiction to enter this petition, my lord.
Likho, item number?
And, my lord, one more, my lord.
26.
7. Item number 7. Lordship will kindly also note that claims are not time burden. Claims were raised within the time.
I will not make any observation. I will just simply record your submission, that's all.
Yes, Lord.
And Mr.
T. Dekhal.
T. Dekhal are a counsel for the petition. Also Mr.
As
S. Bodhakul are a counsel on
behalf of my lord,
on behalf of S.S. Roy, huh?
Yes.
Learned Central Government Council, huh?
Yes.
For the respondent. The present petition has been filed under Section 11 of the Arbitration Consolidation Act 1996. When this matter was taken up, it has been submitted by Lana Council for a respondent that this present petition is hopelessly time barred, in as much time barred for the purpose of appointment of arbitrator.
Yes.
In as much as though the contract was terminated on.
Not, dispute is with regard to the final, dispute is with regard to the final bill. Payment of the
Okay.
final.
That though the dispute relating to the final bill
Non-payment.
or non-payment final bill was raised by the petitioner on
We have raised,
on 4/9/2010, madam.
4/9
we have raised the bill on 4/9/2010.
2010.
Yes,
4/9/2010. He sought to invoke the arbitration clause only on
11/8/14.
11/8/2014.
14, because on 6/5/2014, they have rejected our claim for the final bill. There's a letter of, it is at page number 119, Lord.
The claim is also barred, my lord.
Page number 119.
Page 119. It was rejected on 6/5/2014.
Yes, Lord. Then we have raised in August 2014, we raised the claim within 3 months. That is the date will be, Lordship, 11/8/2014, we issued the arbitration notice after the 3 months after the rejection. Rejection is at page 119.
The petitioner raised the final claim on
4/9/2010, madam.
4/9/2010.
2010. Yes, Lord. Which was
2010, which was however rejected by the authorities only on 6th May 2014.
Yes, Lord.
Thereafter, after being rejected, his claim was rejected, the petitioner invoked the arbitration clause on
11/8/2014, Lordship.
11/8/2014.
2014. Yes, Lord.
2014. However, the petitioner did not approach this court thereafter for appointment arbitrator by invoking Section 11 of the Arbitration Constitution, which was filed, and this petition was filed only on
2020, Lordship. But we approached before the Delhi High Court, Lordship. As there is no territorial jurisdiction of Delhi High Court to appoint, it was dismissed. The order is at page, Lordship, 128.
Page 128.
Then we came in 2021. That is the delay.
Yes. 2014, and accordingly approached the Delhi High Court
Yes,
for
that's
appointment of arbiter under Section 11 of the Constitution, Arbitration Constitution, which however was dismissed by the Delhi High Court on 27/10/2017.
Yes.
2017. Full stop. It has been submitted by Mr. Bodhakul that the petitioner ought to have immediately approached this court. However, they approached this court by filing this petition only on
2021.
2021.
2021.
Which date?
12/7.
12/7.
2021.
2021, which is about 4 years.
4 years.
4 years, and as such, it is hopelessly time barred. And the Honorable Supreme Court also has clearly mentioned, held in
BSNL versus Nortel, Lord.
that Honorable Justice
BSNL versus Nortel, Lord.
that any application for which is clearly time barred ought not, any application for appointment arbitrator which is clearly time barred ought not to be entertained, and relying on a decision of the Honorable Supreme Court in Bharat so. This court of the view that since the petitioner has approached very belatedly, it is clearly time barred as far as the application for appointment of arbitrator under 11 of Sunshine. And accordingly, this court is not inclined to entertain this petition. First time, Mr. Dekha, however, submits that even though he may have, there may have been delay in approaching this court for appointment arbitrator, the cause of action still survive as far as the claim made by the petitioner is concerned. And as such, he may be allowed to, and as such, dismissal of this application for appointment arbitrator under section 11 of this may not come in the way of his pursuing other forum available under the law. And he may be allowed to approach the forum and if necessary, make necessary application for condonation of delay. Full stop. This code, as far the aforesaid submission is concerned, it is for the petitioner to invoke any other alternative forum if available under law, and it is for him to make such application for condonation of delay if permissible under the law. With the above observation,
Lordship, only as far as I am concerned, the claim is also barred, madam.
submits that whatever submits that the claim is also time barred, and however this is an issue which this court is not inclined to enter into.
Absolutely. Lordship will only observe section 14 that word, because section 14 gives us a benefit. Section 14 gives the benefit of.
Look, Mr. submits that he may be allowed to file a necessary application for condonation of delay by invoking section 14 of the Limitation Act. It is for the petitioner to make that is for the वो तो पहले लिख दो बस, that's all. Yes, next. Petition and disposal. Yes, next.
Item number 10.
Item number 10. Who is for the other side? Commander. Yes. Issue notice. Mr. Gupta, Gupta is there? You're there.
My lord.
So what is to be done today?
Lordship, at that day, the matter was that I have not issued the notice to the respondent for appointment of arbitrator 11-6 and directly came before this court. The matter was this one. But my matter is something different. The different thing in the nature that this is the arbitrator, the award which is set aside, that it was given by the fourth arbitrator, not first. When I first apply arbitrator, I give it to the department and notice for appointment of arbitrator, that is here, Lordship, in the year 2004. That is after notice, they appointed the arbitrator after 9th month. Then only that I was agreed because I wanted to get settled, finalize my disputes. Whatever, after that, 3 arbitrators were appointed without my notice by the department as per agreement number. As per agreement number, page 14, Lordship, page 14.
Yes. All dispute between parties contract.
I'll come in at page 14, Lordship, at para 4. Para 4. It says, just a minute, Lordship. Para 4, it says, if the arbitrator so appointed resigns his appointment or vacate his office, or is unable or unwilling to act due to any reason whatsoever, the authority appointing him may appoint a new arbitrator to act in his place. Accordingly, when the first arbitrator resigns himself after doing some hearing, then after 2 years, second arbitrator was automatically appointed under this para number 4 by the respondent. And when the second arbitrator also gone after 2 years, again third arbitrator was also appointed by the respondent. Now this 4 arbitrators who was given the expertise award, that too was appointed without my application based on the first application which I have read. My submission before the court is like that I waited for 45 days from the date of set aside of the arbitrator so that they can fill up the vacancy. But they have not done it. Award was set aside on 11/8, Lordship. I submitted this application on 26th of September. Lordship, I'm submitting one judgment. This is a Punjab Haryana High Court Same my case, as Star Engineering what said this one. It's the same case as today, the Chief Justice of the Punjab High Court. He has given at what is page number or page number 5 and 6, Lordship. 5 and 6. 6 has been highlighted. The main relevant point, Lordship. I'm coming to that highlighted portion. Certain dispute has arisen inter se the parties and the in view of the clause 70 being arbitration clause, the petitioner invoked the same and the first arbitrator appointed in the entered upon the reference in the year 2001. Thereafter, there being a SAG of 8 arbitrators appointed, and the reason stated by the learned counsel for the respondent is that as per the arbitration clause, there was a requirement of having a serving officer, and as and when officer retired or were posted outstation, a new arbitrator used to be appointed. This is same in case law. Then I'm coming the other para. The above said is a completely unsatisfactory situation as arbitration proceeding must conclude expeditiously. The last such arbitrator appointed Sri R.S. Bhandari resigns on 31/7/2013. As per the respondent, the new arbitrator was appointed on 30/10/2013, that is after 3 months. Lordship, then I'm coming, I'll say one thing which is not, thereafter what happened, Lordship, then they appointed 9th arbitrator. When they appointed 9th arbitrator, I went to direct High Court without giving any notice for 9 arbitrator to the Punjab Haryana High Court. Then what he says in the highlight portion, in view of the above stated facts and circumstances, I am of the view that it is a fit case where this court should appoint an arbitrator ensure to conclusion of the arbitration proceeding, as the petitioner cannot be made to wait indefinitely to see the result of the arbitration. And appointed arbitrator, what I have suggested in Chandigarh, I have suggested the arbitrator of Guwahati. The London Chief Justice has appointed the Guwahati arbitrator, Colonel Manoranjan retired Goswami. That mean to say, my first application that stands for that. After that, automatically they have to appoint arbitrator. It doesn't mean, Lordship, how long they will going on to appoint arbitrator, or Lordship, what happened with the award which is set aside. I ask arbitrator, I'm coming from Chandigarh, please give 10 days time so that I come and conclude the hearing. He has not given time to me. They say, we don't have time. As earlier arbitrator also said, we have not done time for this arbitration. I'm having a lot of works with the department. So we cannot believe on their arbitrator. That is my request for this honorable court.
Let us read the order passed by this court in 11/8/2022. What was the
which one, Lordship?
annexes, page 7?
Page 7, Lordship. I'm coming.
On Mr. Ghanshyam Das Hemant Chandra, this appeal under section 37, challenging the order passed in Miss case by application dismissed.
Did it 26/9?
The certain dispute and differential errors been party in respect contract agreement, which was in relation to construct pump house with allies in remote area of Arunachal Pradesh. Initially, one Praveen Kumar SC was appointed sole arbiter who resigned. Thereupon, one Santram SC was appointed as sole arbiter. The appellant herein submitted a seven claim. The respondent filed his statement defense on so and so. Thereupon arbitral comments. The respondent and before the arbiter raised locus and the appellant signal that was authorized to file their claim procedure on behalf of appellant. It is relevant, however, to note that the petition person had submitted 2 power of attorneys. One, therefore, it appears from the present agreement that there was a proceeding. There was initiated before this court rounded. There was a delay in this arbitration proceeding, and the court had to come to by 31 subject to appellant furnishing the required document when it was for the appears from the petition award that the issue was as regards locus stand of the appellant continued to be pivotal on the ground that there was no document produced that the person authorizing the ground that there was no document produced that a person's authorizing some to file arbitration proceeding had the power on behalf of appellant in question. Whether the appellant herein had various occasions request arbiter to have grant an opportunity from the arbiter, it was some opportunity being granted by each the case appellant that is said of nothing but an eyewash in the midst of the opportunity to so granted was inadequate. In wherever the arbitration was decided only by hearing the respondent in the argument question the claimant that is the appellant hearing why not heard it, and then it further appears from record from arbitration award that are did not in personal claims or raised in the claim proceeding, but rather external that the claimant had no reason for filing getting any claim under the arrest essentially question. In on episode there of past nil award. We also put in though the respondent sought for imposition of cause of particular being the cause involved in proceeding, to bear on cost. That's how I publish on being agreement preferred person. This is on footage of the set was registered numbered. Dismiss said on the grounds of objection so as or do not come within the ambit of section 34. Yes, Mr. Gupta, have you filed your objection to this application?
No, Lord, we are still
Then?
awaiting
Huh?
instruction. I am still awaiting instruction from the department.
What, how long will take instruction? Huh? This, I see notice was shown 28/9/2022, within 3 weeks.
But here, my lord, after the setting aside of the award,
Yes.
my lord, the parties would be relegated back to their original position.
Hmm.
And as my lord, provided by the Honorable High Court in its order, while setting aside the award, my lord, in paragraph 13, the parties, if so advised, may take appropriate steps for settling the dispute in accordance with law. My lord, the dispute would be addressed, but my lord, dispute as raised by the petitioner would be addressed, my lord, but the appointment procedure has to be followed, my lord, now as per the agreement.
What is the agreement?
My lord, the agreement.
According to what is the agreement?
My lord, page number.
Page 14, Lord.
14.
Page?
1/4, Lord.
This is agreement.
Yes, sir.
Is the general.
All
that is
dispute
clause
parties
17.
so shall be after written notice by either party. Sole arbitrator, unless both of parties agree in writing.
My lord, this procedure has to be followed, my lord, because
Unless both of parties agree in writing, such shall take place after completion. See, Mr. Dhiman, see, in the one which you referred, para 4, if the arbitrator so appointed resigns his appointment or vacates his office or is unable or unwilling to act due to any reason whatsoever, the authority appointing him may appoint a new arbitrator to act his place. The arbitrator shall be deemed to have entered a notice.
that is the case where the arbitration is pending, my lord. Here, the award has been set aside,
The venue of the arbitration shall be.
but the judgment is relied upon.
And the earlier arbitrator was appointed by whom?
By the same authority, Lord.
So let him appoint.
No,
Let him appoint then in that case.
but in 45 days, they have not appointed Lordship.
So we'll direct them to appoint.
No, sir, it is not like that.
Why not?
We cannot wait for until, or one thing is my submission, next
then-
my submission, Lord.
But then, see, you are the one who is aggrieved, no?
Lordship,
You are the one who is
I'm
aggrieved.
aggrieved, I agree.
You are,
sir.
you are the one, suppose if they just simply keep quiet, who will get benefit? They will get benefit. You are the one who will suffer. Suppose both of you decide to sleep or not to act, take rest. Who will suffer? You are the one who will suffer.
Lordship.
So therefore, you are the one who had to activate the system. You are the one who had to activate the law. Say that no, what are you doing? It has been set aside now. Yes, it has to be settled as per arbitration we appoint. You do not say that. You have come straight to this court.
Lordship, one submission, more
Yes,
submission
yes.
is there, sir. Though it is a act of 1940 Act judgment of Supreme Court, but the facts are the same.
Which one? Which act?
I'm giving it, Lordship. The facts are the same, Lordship. And I'm going to head note thereafter, para number 3, Lordship. Head note, Lordship, that whether the Supreme Court had retained control over the arbitration proceeding when the matter reaches to Supreme Court, whether right to appeal should be preserved. Supreme Court setting aside earlier award on the ground of misdirection in law and referring 3 claims item to a new arbitrator nominated 8. Then I'm coming to para 3, Lordship. Bharat Cooking Limited or Annapurna, para 3, Lordship, a highlighted portion. While setting aside the award, Director SC 174, para 41. However, as noticed herein before, this case stands on a different footing, namely that the arbitrator, while passing the award in relation to some items, failed and oblique or neglect to take into consideration the relevant clause of the contract, nor did he take into consideration the relevant material for the purpose of arriving at a correct facts. Such an order would amount to a misdirection in law. This is now second 41, highlighted is important. The instead and that and instead and in place of remitting the matter to the named arbitrator, that is in the
I
agreement.
see, yes, but the only one distinction between this difference is that the Supreme Court can always do that. See,
Yes,
under 142, you know.
So they have not applied 142. I have having lot of judgments on that. Lordship, I'm sorry interpreting. And while when the award was set aside by earlier.
Okay, then why don't you produce any judgment by the High Court of the High Court also, or any provision saying that yes, if any interference by the High Court can do it on its own.
Lordship, when the meaning of this is when the Supreme Court set aside the award, he is the power or control over the arbitration and appoint arbitrators as it is appointed over here.
Correct. But then see,
It is not apply 136 or 142 article. Lordship, I don't believe on that. 4 arbitrators they passed on. This is a wastage of time. There was a contract for 1 year. They have taken 14 years, Lordship, only to decide it. Why should I believe them? I'm getting loss out of that. I'm coming this honorable court for appointment of independent arbitrator. Nor there, nor mine as independent. Lordship, I am very I've lost so many things.
That is another thing, but then power of the court, the arbitration.
Lordship, this is I'm one thing. This is actually regarding the notice. I'm submit, Lordship. This is the notice. Please, sir. This is notice under which they have appointed, and this is continued till the matter is decided in arbitration. You need not to give again and again notice for that one. This is whatever we have in 2004 for appointment of arbitrator, Lordship.
But it is only where an.
I have enclosed the disputes also, the list of disputes that.
But then if you have written a letter, if they have not acted upon that, but we have not at all. See, that's the problem, no? Because the law also we have to decide and not on the basis of pure fake situation, but must be based on certain norm. What is the principle? If you have written there now, it should be appointed, you should be appointed, and they don't act upon it, then yes, you can always do it.
Lordship,
but we have come straight to the High Court. Therefore, the High Court, what is the power of the High Court to appoint straight away?
This is the judgment of Punjab Haryana High Court. Same thing as what we are. This is my case. Same thing, Lordship.
We don't know in this.
High Court, my lord, it was not set aside.
There have been
The award is set aside, my lord, and direction
Sir,
was given.
Lordship, I'll tell one thing.
The dispute in accordance with law, afresh. It's not applicable.
See, we have to go by the act. No, we cannot go beyond the act.
Yeah, Lordship,
What empowers? You saw section 11.
Lordship, my submission regarding the act is that act we have applied. I have applied according to act for appointment of arbitrator, but they are neglecting their.
No. Where is it? What it was set aside by the court. No.
Sir, Lordship, it was always.
Parties, if so advised, may take appropriate steps for settling disputes in accordance with law. In accordance with law would mean, my lord, he has to again make an application. Notice has to be issued under the, after the arbitration clause.
Appointment shall be made on application of party.
We will appoint it in.
That is for first time, Lordship, for first arbitrator to appoint, that act applies, not thereafter.
See,
As
you have
section
to-
11(6). Sir.
If you give time, I don't know when I will, because I don't have time to do research now. You have to find out yourself that yes, under such circumstances, the High Court also can appoint.
Because the award is no more, my lord.
Correct. We have understood your, I have understood your position, but then I must be also guided by certain judicial
That
precedents.
Punjab Haryana.
We don't know that Punjab Haryana, whether who has
Lordship, may I bring the certified true copy of the statement of the government of Union of India, which is submitted before Punjab Haryana High Court, on which this judgment has given. I'm ready to bring that.
You will bring that because I don't know the facts of the case.
That's definitely, that is, I'll bring Lordship.
Yes, yes. List the matter again on so and so.
Lordship,
When?
then I'll go to Chandigarh and come. It will take time. Lordship.
When then Monday?
No,
Or
not
when
Chandigarh. I have
Oh,
to
so
go.
you'll go come back.
Then I have to bring record from
Okay.
there, High Court, Lordship. Then next month, Lordship, in December.
Okay. You should have brought a judgment whereby, see, Supreme Court, see, relying on Supreme Court is slightly different because Supreme Court can pass any order, whether they mention it under 42. But then, and this is a 2008 Arbitration Act 1940.
Lordship,
And now this changed, Act 1996. And how arbitrator has to be appointed only under Section 11. Under Section 11 of the Act that we can appoint, but give us some idea have the power to designate. There is no whether suo moto, failing agreement, parties agree, see, wherever agreed upon parties. See, it is only when the
okay, sir.
Sir,
Give me permission to bring
Yes.
the other things so that I can
Yes.
convince the court only.
yes,
Otherwise, mostly it had what it will be done. It be premature. It will called as a premature. My application. I'll bring the decisions, Lordship.
okay,
In December, kindly, sir. In the
okay. List again on so and so as spread by Mr. Dimon. Yes.
712.
Lordship. So, how much?
Item number 11 for orders.
In this case, my lord, the records were called for. Only the government is yet to get the records, my lord. So may the matter be taken after 4 weeks.
Okay. On the prayer of Mr.
Are they? The government,
they? Huh?
the government was directed to produce the record. My lord.
Okay.
The records have not come. He's for the respondent.
Okay. So who is for the petitioner?
But I am for the petitioner.
Review petitioner, na?
Yes, yes.
And government you have to produce the records.
No,
I am petitioner, private respondent.
The government, who is for the government?
Here, my lord, they already had appeared, my lord. And in fact, I had confirmed below that the records are not here.
Okay. So list again after?
After 4 weeks.
The 4 weeks. Okay. To enable the government to produce the records. Yes, 11. Then number 12.
Item number 12.
12, anybody? Abdul Hamid. Okay, pass over on the prayer of Mr.
B. Bora.
B. Bora for
On
the
behalf of
review
I.
petitioner. Yes, on behalf of Mr. I. Sakya. Yes, next.
Item number 13.
Pleasure.
What is this?
State
Article?
government is there. They are yet to file the counter affidavit.
Huh?
Mr. Dana, some legs, my lordship.
But you have to file counter affidavit.
I think we have some paragraphs coming.
Here you got here receipt. Okay, what is your name?
And
N. Bormon appear on behalf of
Dina.
Dina, standing counsel submits that the state government is preparing the counter affidavit and place for 2 weeks time to file, at least after 2 weeks. Yes, next.
Item number 15.
Yes, 15, BK Das, anybody?
My lord.
Yes, what is, who is for the other side?
Malad ji, the government is.
And then what to do?
Other side. Malad, she is government council.
She is government counsel, she doesn't know anything. She's just carrying some files on behalf
The
of
fact
Dina.
hearing is that there.
Oh, why you are arguing? There nobody is there.
Somebody will, because some agency, this petitioner is going to be retired on 20th, my lord. And my lord, that he has been, my lord, rebut back after promotion without any notice to his, my lord, original post.
Yes, who is with the other side? Yes. GA. Who is the GA? Who is the government advocate appearing at a time?
My lord, they review for the first time. My lord, Dinath, perhaps.
Dinath.
Dinath, my lord.
Dinath.
She is the junior of Dinath, perhaps, my lord.
Appear on his behalf, my lordship.
But the Dinath is not here to what to do.
My lord, there is some agency, and my lord, another fact I would like to draw your lordship condition, my lord.
Oh, there is no point.
My lord, the similar petitions, my lord, that has been preferred by the, my lord, identical, my lord, similarly situated, my lord, petitioners that has been, my lord, disposed of.
Where is the order? Where is the order?
Order herein, I'm mixing, my lord.
Okay, then we'll.
I'm seeking only similar order, my lord. All this, my lord, these petitioners are, my lord, a lot of, my lord, persons, a series, my lord.
Mr.
BK Das, my lord.
Who submits that the similarly situated cases have been already disposed of by this case. Referring to annexure.
Annexure, my lord, that is on. My lord, on annex, that is, my lord, page 67, annexure 4, my lord.
Annexure 4.
Annexure
Order dated
order dated, my lord, on passed on 16/10/2020, my lord.
Passed in,
16/11/2020.
passed in which petition or?
Passed in, my lord, that is with petition number, my lord, review petition number 94/2020.
Review petition number 94/2020.
2020.
It has been submitted accordingly. This review petition may be also allowed. Yes, the state government will ascertain by the next date.
My lord,
Next day, when- what to do now? I can't pass order without
my lord, can be, my lord, everything identical.
next week.
My lord, next week he is going to be retired, my lord. That is the problem. Oh, that's why, my lord.
Don't
Because,
worry, you will get all the benefit, doesn't matter.
my lord, after
Pending-
retirement, my lord,
After retirement, what?
my lord, he may not be, my lord, promoted.
What?
my lord. Promoted, my lord, because, my lord, this, that
You
after
get
this,
a notional promotion.
after this, my lord, this.
You get
ongoing
notional promotion.
process, my lord, notional.
Our high court does not function on the
Well,
date
in
of
spite of,
retirement.
Malad,
na.
what I'm
You
trying to
get
say,
the
Malad.
benefit.
My lord, in spite of passing these orders, my lord, after setting aside the, my lord, interim reversion order, my lord, they are not allowing us to, my lord, to join in our
They have been
promotional.
submitted by Mr. B.K. Das that the petitioner is going to retire with effect from
On, my lord, on 24th.
24th.
My lord.
23rd will get the order.
My lord. This, my lord,
This 23rd fix.
only because of my client's interest.
23rd fix. We'll pass the order.